Mr. Burton, good morning.
Good morning, my ladies. Good morning, my lord. I appear on behalf of the claimants in this matter with my learned friend, Mr. Rutledge, behind me.
Yes.
My learned friends, Mr. Brown and Mr. Carter, appear on behalf of the Secretary of State.
Can we just talk about timetable?
Certainly, my lady.
You know that we need to rise at 4 o'clock. Have you discussed with Mr. Brown a share out of the day? How do you propose to proceed?
I'm afraid we haven't done that.
How long do you think you're likely to be?
I was planning on taking the morning and then leaving a short period for a reply in the afternoon. Maybe I can get done sooner than that. If I just set out how I was going to put my submission.
Yes.
First of all, I was going to do a very brief introduction into the sort of factual issues, really, most of which will probably be very familiar with you already, but just to put down a couple of key markers. Then just give a very, again, brief outline of what the claimant's substantive, or appellants, I should say, substantive case is on the JR.
Yep.
But then, of course, move on to the ground of appeal. In terms of the law, I'm not sure we're that far apart, and indeed,
No,
I will probably,
don't think you are.
Yes, I will probably just rely essentially on what's in the skeleton argument in relation to the law, maybe making 2 points that my learned friend makes about that. And then, of course, look at the judgment in a bit of detail, because,
Yeah.
of course, that's important. And then, depending on where we are in terms of time, I would like to develop a little bit more about the substantive case, because, of course, if we get there, then it will be a matter for this court to resolve that question.
Yes.
And there are a number of points I'd quite like to make. Now, depending again on time, maybe I can save some of them for the reply, etc. So perhaps we can see how we're getting on.
All right. Well, it sounds like I think you should be done by lunchtime.
Yes, my lady.
That will leave sufficient time both for Mr. Brown and also for a reply.
Most great. So, my ladies, my lord, just in terms of the first issue, brief introduction into the sort of factual matters. Again, these are really just putting down some key markers. So what we're concerned here with is the means-tested benefit system that provides assistance with generic basic living costs and additional amounts for variables, housing, children and disability, commonly referred to as subsistence payments, in contradistinction to an income replacement system that's more familiar on the continent, and essentially, as Mr. Hanscom, the economist from the Resolution Foundation, puts it, a system that is focused on preventing poverty, as opposed to providing a state-backed insurance scheme. Second, you will have, of course, picked us up that universal credit is gradually replacing the legacy benefits, and any new claims for legacy benefits were impossible after the 27th of January 2021, although, of course, that only applied to a small subset. The majority of new claims had to be for universal credit after about December 2018. We are concerned here with the basic allowances, which are, of course, common to both benefit systems, if I can put it that way. And those basic allowances serve an identical purpose, which is to contribute towards basic needs, and have been set at the same level, essentially, since universal credit was introduced in 2013. Of course, that changed on the 30th of March 2020, when the government decided to increase the standard allowance for universal credit by approximately £20 a week or £80 a month.
But you don't challenge that decision?
We don't challenge that decision, no. Of course not. Fundamentally, because the merits of that decision are clear. What we challenge is the failure to do a similar increase for legacy benefit claimants.
Well, not at that time. That's
not
my
at
point.
That time. Yes,
you don't challenge the failure to uplift for legacy benefits in March 2020.
No, that's correct.
Your complaint is about March 2021.
Effectively, yes. I mean, the way the pleadings are put is that we say the position was sufficiently clear, or ought to have been by January 2021, that this was no longer a justified difference in treatment.
By January 21?
January 21. That's the response to the pre-action letter. And that was the pleaded case, and indeed what was set out in the skeleton argument below. The references for that are in the skeleton argument, paragraph 5.
Yeah.
this is an appeal which is squarely focused on the disability discrimination. It is indirect, although I will develop that submission a little bit more if we get there about why it's a certain type of indirect discrimination. The basis upon which that was understood by the learned judge below is at paragraph 25 of his judgment, where he says this: the factual premise of the claimant's claim is that the number of disabled persons in receipt of legacy benefits as a proportion of persons still receiving those benefits is greater than the number of disabled persons receiving universal credit as a proportion of the total number of those claimants.
And you don't quarrel with that?
No, I would suggest that's potentially incomplete, however.
Incomplete?
Incomplete,
okay.
in the following way.
Yep.
And this is what we said in the detailed statement of facts and grounds, paragraph 77, which is at page 238 in the core bundle, that approximately 1.6 million, i.e. 85% of ESA claimants are in the...
Sorry, 1.36 million?
1.6 million.
1.6 million, which is 85%, you said.
85% of the ESA claimants are in the support group. Just pausing there, support group is a proxy that we've been using for disability, although it should be pointed out that that is a high level of disability. I'm going to show you another document in a moment which might be more useful as an indication of the scale of the disability discrimination in this case, although I obviously stress that that's not an issue. There's no dispute here that there's a disparate impact on disabled people as a consequence of this difference in treatment. Whereas there is 0.9 million, that's 18%, of universal claimants were similarly unable to work because of a disability.
Also with the same high level of disability or just with disability?
That's effectively the same high level of disability.
Yeah. Okay.
Therefore, a disabled recipient of Social Security is disproportionately likely to be on ESA rather than universal credit.
Hold on, say that again. A disabled recipient
of Social Security.
Of ESA? Or?
No, so the way I look at this is I look at the whole pool of people who are on benefits for disabled, and then you can see quite clearly in both absolute terms and as a percentage of the respective cohorts, far more of those are on legacy benefits than they are on universal credit. Now, what there is in the papers, I don't know if you've noticed this, is a table at the end of the supplementary bundle, which was prepared for the benefit of the court below. It begins at page 255. Before I look at that in any detail, my learning friend will tell me if I get this wrong. But my understanding is this is essentially agreed. There was a little bit of quibbling about some of the precise numbers. I'm just looking at my learning friend to see if he's essentially...
I don't think it ever was agreed at all.
Not agreed?
Oh.
Right.
Well, that's not quite my understanding, but it may not matter. But just to explain in a little bit more detail about how these statistics are set out, and maybe we...
So whose document is this?
So this was prepared by the claimants below. I think the numbers are generally agreed, but again, my learning friend may say there's some discrepancies he wants to highlight, but the general thrust I certainly understand to be agreed. And what this table attempts to do is just to draw out some of the numbers in a bit more detail. But of course, it's important to add that nowhere does the DWP record disability. So we are looking at proxies, and the proxies are essentially one's capacity to work or otherwise because of disability. And there are three different categories for that. There's having a limited capability to work, a limited capability for work-related activity, and then there's being a carer for a disabled person. And so in the top of the table, you'll...
Sorry, could you give me the three categories again?
Limited capability for work.
Carer and...
No, limited capability for work-related activities is the second, and then carer.
Yes. So limited capability to work. You may not be able to work because of your disability. Limited capability for work-related activity means you may not even be able to look for work.
Thank you. Yeah, that's what I was missing. Thank you. Thank you.
And then you'll see that the way the table is structured is you've got a caseload, which is the number of people who are receiving the particular benefit, and then 4 different dates through the passage of this particular difference in treatment. And then helpfully some percentages. So the first one is number and percentage of total with limited capability for work-related activity. So the most serious form of disability as a proxy. And you'll see, for example, that as of February 2020, just before the measure, of the total UC and legacy benefit caseload, 36.4% would meet that criteria. Of the total UC caseload, when separated out, only 15% would meet that criteria, and you've got the absolute number there. And again, similarly for those on ESA who hit the support group, i.e. they are deemed to have limited capability for work-related activity, you see it's about 85%. And then going further below, the same exercise is done for limited capability for work. And then those two are combined in the third one. So treating both limited capability for work and limited capability for work-related activity as being good proxies for disability, we do the same exercise there. And in essence, what you see is about 40% of the overall Social Security caseload looking at these subsistence benefits have those proxies for disability. 22% of the universal credit caseload, about 412,000 in February 2020, and about 77% of the ESA caseload, which is just short of 1.5 million. And then you do the same exercise. I don't necessarily think we need to look at it now when you add in carers. So the general position here is that you see a very clear tendency that if you've got disability, particularly serious disability, you're much more likely to be on legacy benefits than you are on universal credit.
Sorry, I just want to get to claimants. So we've agreed the numbers. I think our only concern was that we would have wanted to have put more information in this in order to present what we would say is a fuller picture. So the numbers are reliable in the document. It's not that we take issue with.
Okay, thank you very much. But in any event, this is the foundation, is it, for the judge's conclusion in 25 that there is an indirect or a disproportionate adverse impact?
My understanding is that's correct. It is not specific.
He doesn't unpack it, but that was the material before him.
Yes, and there are some other statistics which are already in this bundle, but they are basically, it's from DW statistics that we produced the table to try and give us all one place to look at it effectively. So my ladies, my lord, just moving on then to the second heading of my submissions. Brief outline of substantive case on the judicial review. There were a number of legal issues before the learned judge below. They were all effectively resolved in favour of the claimant in terms of being able to then move on to the justification issue. But of course, the learned judge found against the claimants in relation to that question. But that's the sole issue before this court. Effectively, did he approach the question of proportionality correctly? We say not. Of course, the Secretary of State says he did. If you're with the appellants, then you move on to decide that issue for yourselves. It's therefore necessary, I think, to go straight to the heart of the matter and look at what the DWP said as being the justification for this difference in treatment. And we see that...
Well, that's at the second stage of the argument. The first stage of the argument is to show that the judge made an error, isn't it?
Yes. The reason why I was taking my submissions in this way is because I wanted just to make it very clear what the justification was, give a brief outline of what the claimants and our appellant's case is about that, which I believe will help us better understand why we say the learned judge got the exercise wrong.
Yeah.
I will do this very quickly. I'm not going to use this as an opportunity to
re-argue the case.
But if we may just look at one paragraph, therefore, of Ms. Parker's witness statement, which is the evidence of the Secretary of State in relation to justification. So paragraph 43, which is in page 65 of your supplementary bundle. And there it's explained that the DWP was focusing its resources on those who were most, sorry, let me start again, those who were likely to face the most financial disruption from the start of the pandemic, and also adopting a flexible approach to the way that benefits are administered. This has meant targeting support of those who have lost income as a result of the pandemic, rather than those who may have faced increased costs, which could not have been accurately calculated. I note that the claimant's evidence is that they have faced increased costs, etc., because of the pandemic. Government recognised this may be the case, but it's likely to be so for very many individuals. The government focused its response on those who had lost income, who would also likely face increased costs during the pandemic, as it considered they were likely to face the greatest financial disruption. This also assists in providing a cushion to individuals who suffered short-term loss of employment or reduction in employment, but who would be expected to return quickly into the labour market. So just a couple of very quick observations about that for current purposes. This is a justification in relation to a prospective measure. It's an anticipation of certain factual scenarios. It's also predicated on a comparison. It's a comparison about who will experience the most disruption. And the conclusion on the basis of that assessment is it's likely to be people who've lost income, not faced increased costs. And the essence of that justification is repeated again by the witness at paragraphs 51, which is page 69, paragraphs 57, page 71. And then at paragraph 58 at page 71, I wonder if we just quickly look at that. What is the connection between the measure and the identified need? And it's paragraph 58. The DWP has substantial expertise in evaluating the effects of unemployment on society. Sudden and short-term unemployment is capable of triggering other social problems and affecting mental health, and result in a situation in which a person becomes dependent on welfare and hampers a return to employment. Even where there are vacancies, these effects are likely to be exacerbated by the pandemic. Follows that seeking to prevent these social problems from arising following sudden employment can benefit individuals and society. The substantive case of the appellants below, in very brief terms, is as set out in paragraph 3 of the skeleton. If I could just give you 3 broad headings. One, there is an in principle issue. There is no reason in principle for distinguishing between new and existing claimants, given that the common purpose of the basic allowance in universal credit and legacy benefits is to provide for basic living costs, not to replace lost earnings. Second heading is, in fact, the measure itself, the increase of £20, not particularly effective at limiting the shock of sudden employment. That's because the feature of the UK benefit system is that anybody who moves from work onto benefits will experience a very sharp drop in income that's built into the system of subsistence rather than income replacement. And for all intents and purposes, this was really an anti-poverty measure. When properly understood as such, it becomes much harder to justify giving it only to universal credit claimants and not to those on legacy benefits. In any event, the factual assessment about comparable levels of disruption is not made out on the evidence. The uncontested evidence before the court was that new claimants for universal credit were better able to deal with the disruption caused by the pandemic than existing universal credit claimants, both of whom, of course, are receiving the uplift, and by extension, much better able to deal with it than people on legacy benefits who did not receive the uplift. We see that in clear evidence about being unable to pay their bills, using food banks, and going into debt. In any event, on the question of disruption, the way in which people came onto universal credit after March 2020 was in a very sharp flow right at the outset. By mid-May, the vast majority of new people who came onto universal credit were already on it. And so the submission of the appellants was, over time, their circumstances are going to be very similar to everybody else who's dependent on the safety net in order to meet their subsistence needs.
You have to say that that over time was only 12 months or 10 months, not 18. Because...
yes, I mean, needless to say, our case on justification is it's when you take all of these factors into account that the measure ceases to be sufficiently justified as to be compatible with Article 14. That's a very important point for us. Because, of course...
That it's all the factors.
It's all these factors combined. The next point about disruption, I'm still dealing with that heading, is, of course, that for what wasn't apparent in March 2020 but became apparent was just how adverse the impact of the pandemic was for disabled people. Not just in medical terms, but in terms of the cost of living and the disruption caused by having to cope with the pandemic. Just by way of example, at the moment we're talking about PPE, we're talking about having to shield, we're talking about not being able to go to the shops, we're talking about all of these increased costs, extra utility bills, etc., which were particularly acute, again, on the uncontested evidence for disabled people, and therefore predominantly people on legacy benefits. Again, very relevant to this comparison exercise about levels of disruption. And then there are two final points which are relevant, we say, to this assessment of proportionality. That there was an arbitrariness to this, because, of course, all existing UC claimants got this in addition to new UC claimants. Indeed, there were more existing universal credit claimants than there were legacy benefit claimants at the beginning. And second, that distinction only arose because of the manner in which the government decided to roll out universal credit. And then finally, on the question of technical capability, we say that insofar as it was an obstacle, it was clearly one that could have been overcome in some way at an appropriate time. And of course, I'll try to address that by reference to the facts in due course in a moment. So, as my Lady Justice Simler already pointed out, we didn't say this was a disproportionate measure at its outset. We recognised the exigencies of the situation. We also recognised that there clearly were some technical problems about doing something about legacy benefit claimants straight away. But what we say is this: true it is that some features of why we say this was a disproportionate measure in January were present at the outset. For example, in not being a particularly effective way of replacing income and avoiding the shock, and the fact that it was already from the outset being paid to existing UC claimants. But added factors came later, and in particular, the evidence that goes directly to the heart of the justification about comparable levels of disruption. We didn't know about the nature of the demographics of new people coming onto universal credit who had more money available to them to cushion themselves. We didn't know, on the other side of that equation, just how bad this was going to be for disabled people. That all becomes apparent later on. And when you keep in mind this is a prospective measure saying this is what we think is going to happen, so we're going to do this, what in fact happens is highly relevant to the court's evaluation of whether or not that transpired to be a compatible measure. In other words, it struck the correct balance between the interests of the legacy benefit claimants and the society as a whole. Hence, that's why the challenge was always put on the basis that it was accepted the measure was initially a proportionate and compatible one, but then ceased to be so when those other factors were taken into account. Of which I should also add that you had this camel hump of new applicants for universal credit, which was not replicated at any further point in the pandemic. So, my ladies and my lord, can I then turn to the third heading, which is the judgment?
Can I just lay down a point that we've talked about the purpose of the measure initially being disruption, and there's plenty of evidence of that, and I accept that. But I'm sure the Secretary of State will say that it can't be limited to that, because it was a sort of three-limbed strategy, wasn't it, which is what the witness sets out on page 69 and 70, that it was to do with cushioning those who were losing their jobs, who were disrupted financially. but it was also to do with rapid implementation, so the capacity to deal with it, and to do with sort of what I've called optics as well. It was a morale booster for society. So we just need to be careful that it wasn't just about people who were disrupted, and then you equate one person's disruption against another person's disruption.
Can I just address that immediately? The first is that in the context of scarce resources, they say we've got to prioritise, and therefore we've identified these people suffering the most disruption, and therefore they're most deserving of the resource that's available, which then has certain spin-off benefits. So I do maintain that comparison exercise is absolutely essential to the decisions that are being made early on. The second point about practical implementation, we accept, indeed that's a large part of why we say initially this was a difference in treatment which probably had to exist. We don't accept that for the duration of the measure. But thirdly, on the final one, really importantly about this clear statement of policy, if I can describe it that way. What that was saying we're going to do something for people adversely affected and put money in their pockets. And had the government said at a slightly later point in the pandemic, and we're now going to make the same measure, effectively, by one means or another, for people on legacy benefits, so they are also protected, particularly now, for example, we might be aware of the particular difficulties they're facing as disabled people, it would have done something very similar. It would have been a clear statement of policy that the government is here to support them. And for what it's worth, this isn't an argument about economic policy, but for what it's worth, Mr. Hanscom, again on behalf of the Resolution Foundation, says that would have had quite clear benefits in the sense that people who are on low incomes go and spend that money straight away in the shops, etc. So it's money that would have been recycled into the economy. So yes, it couldn't have happened at the exact same time, my lady, I understand that, but a similar type of statement, similarly bold and similarly clear, we say was plainly available to the government at a later point in the pandemic. I will say something more, I'll just flag this now if I get to that stage, about what I say is a slight discrepancy. It's why we say this was a fundamentally an anti-poverty measure. It wasn't really anything much else than that. Of course, a very important anti-poverty measure. But some of the claims that are made for this £20 a week, we would suggest, are not only unevidenced, they're too grand. And really, really what was happening here fundamentally was the government was clear that universal credit would not be enough to avoid new people experiencing significant hardship and therefore increased it so as to try and mitigate that. Now, my ladies, my lord, will be conscious that, of course, the appellants have only got permission on ground one.
Yep.
And effectively, ground one says, don't want to misquote it, judge's approach is based on the mistaken belief that if a measure is proportionate at the time it comes into force, having regard to the circumstances prevailing at the time, it cannot subsequently become disproportionate, notwithstanding the discriminatory impact it has on a group of persons, here disabled claimants on legacy benefits throughout the lifespan of the legislation. And that's the focus that I'm going to try and draw out from the learned judge's decision below. Did he really grapple with that question? This may not be a perfect analysis, I accept that right at the outset, but we say the thrust is very clear when one looks at the totality of his judgment on this issue. So, my ladies, my lord, the relevant passage begins at paragraph 30. And I'm going to take us through that, and I hope by the end of it I will have effectively made my submissions on that one.
Yeah. So you don't quarrel with the self-direction the judge gave at 29, having reviewed Lord Reed's judgment in SC.
Well,
you're starting at 30.
When you say I don't quarrel,
well, I know you've got your Wilson point.
Yes.
But you don't quarrel with his approach by reference to SC.
If you just give me one moment,
yeah.
My lady. I've extracted the judgment parts that I need to look at, so I'm not looking at it in its proper place. I'll just do that now. Yes, I mean, we did bring a grounded challenge about that.
I know, but you don't have permission.
No, that's correct.
Right.
So
you've
for
proven
current purposes, we
Yeah.
accept that
Yeah.
that is fine. What I will say again, just to be clear and flagging it, is that the question of very weighty reasons and the rationale for having the very weighty reasons jurisprudence is something which we will say, if we ever get there, is highly relevant to the balancing exercise that has to be conducted in the context of this case.
But he recognises that by talking about disability as a suspect ground, doesn't he?
Indeed.
Yeah.
But what I'm going to say now, and just so it's clear, is we will say that when you conduct, if you get there, the proportionality exercise, you must have very much at the forefront of your mind the explanation for why we have very weighty reasons, because it is very relevant to this case, and it's also very relevant to the fact it's indirect discrimination and what the significance of that is. I'll develop the submission more fully then. So it's not a quarrel with him.
No.
If that door opens again and the court is looking at the question of proportionality, then we will say something very brief about weighty reasons.
Okay.
But yes, otherwise we're just looking at the substantive conclusions of the judge, which begin at paragraph 30. In paragraph 30, of course, sets out that the origin of his understanding for the justification is the evidence of Kirsten Parker, and indeed that's the only evidence the Secretary of State put forward which directly addresses the difference in treatment. We've seen that. It says by the end of March 2020, the government's objective was to take steps to preserve stability in the labour market, short term, provide a basis for rapid economic recovery, etc. The best known measure was the furlough scheme, of course, which made it possible for many who would otherwise have been dismissed in consequence of March 2020 lockdown to remain in employment. Then the increase in the standard allowance was a way of providing additional support to those who did lose jobs or income because of the pandemic and became reliant on universal credit for the first time. This group would face particular disruption as a result. Now, this isn't directly relevant to the ground, but I do think it's important to understand that this use of the word particular disruption as opposed to the greatest or the most disruption is relevant in our submission.
Relevant to what?
Relevant to how we develop our ground one, because by identifying it as a particular disruption, he's omitting the important step in the government's analysis, which is they've looked at comparable levels of anticipated disruption and concluded that those who are going to lose income as a consequence of the pandemic will face the greatest. So it's not just about a particular type of disruption, it's a comparable level of disruption. And she says, Ms. Parker explains that the increase was intended to cushion the sudden impact of loss of employment or reduced employment. I accept this was a legitimate objective. The decision to increase the standard allowance was made in anticipation of a dramatic rise in the number of new benefit claimants. The evidence before me shows that this is what happened.
So are you saying the judge, by using the word particular disruption, the judge was overlooking the fact that there was a comparable exercise conducted? Okay.
Now, it's an unpromising start when I immediately have to highlight a fly in my argument about, fly in the ointment, I should say, about the argument about how the judge approached this exercise. I freely accept that, because what he then does in relation to one factual question is look at how the anticipated outcome matched the reality, which is how many people came onto universal credit. And I accept that. But he doesn't do it again. He doesn't do it again in relation to the really important parts of the case I'm going to submit. And indeed, he doesn't really highlight the point that we were making about that issue, which was it was a big hump at the beginning, and then effectively the numbers of new people onto universal credit was very similar to the position before the pandemic, because of course people were moving naturally onto universal credit from legacy benefit claimants as the churn of people on Social Security developed. But he does say, I accept, at the latter part of paragraph 30, that the anticipation or the judgment that was made transpired to be correct in the sense that, yeah, lots of people did come on to universal credit. Then he moves on to paragraph 31. The central question raised by the claimant's discrimination claim is whether it was lawful for the Secretary of State to direct her attention to the position of new benefit claimants. I mean, that's quite what we'd say. We'd say it's exclusively to them, but leaving that aside, all of whom would have made claims for universal credit, I consider that she was. New benefit claimants would need to adjust to loss in income. They would be affected differently to persons already claiming benefits. He doesn't go on to then say, but did they suffer greater disruption because of the pandemic? Did he then question what happened? Did he do the same exercise he did in relation to the anticipation about new people coming onto universal credit? With respect to the judge, he doesn't. Given the objective pursued by the 2020 regulations and the circumstances in which the decision to make those regulations were made, legal scrutiny of the decision to make the 2020 regulations must allow the Secretary of State a degree of latitude. Of course, we accept that. But we must understand what actually happened in terms of comparable disruption thereafter, because we understand the exigencies of the situation may have demanded a quick response. But when you're evaluating whether or not this measure is compatible for its duration on the basis of Wilson, then you need to look at all the evidence that's available to you now. All this being so, the judge continues, the distinction between the legacy benefits, personal allowances and the universal credit standard allowance consequent on the 2020 regulations rested on sufficient reason. So there is no answer to the question at that point about how the assessment about comparable disruption panned out in real terms. Then at paragraph 32, here dealing with the point about the fact that no distinction was drawn between new UC claimants and existing UC claimants. And the learned judge said, I have no doubt that distinguishing between these two groups of universal credit claimants and paying the standard allowance at different rates to each group would have given rise to technical difficulties. Okay. Not the least because it would have been necessary to establish the distinction almost immediately with effect from the end of March 2020. But there's no evidence that this couldn't have been addressed at a later point. No evidence to say, and of course that had to be sustained throughout the duration of the measure. Be that as may, looking at the situation as it was in March 2020, the Secretary of State was entitled to draw the line between universal credit claimants on the one hand and legacy benefit claimants on the other. Then at paragraph 33, Ms. Parker's evidence includes the following, paragraph 53 of her statement, which I consider adequately explains why the Secretary of State took the approach that she did when making the 2020 regulations. Nothing wrong with that, but not an answer to the question before the learned judge as to whether it was also permissible for her not to increase the personal allowances for people on legacy benefit claimants at a later point. And there we see the statement, the evidence of Ms. Parker in relation to the second point raised by my Lady Justice Whipple about clear statement, which is again absolutely orientated in time towards the 20th of March 2020. Doesn't look at the possibilities of making a similar statement a couple of months later or however longer later, saying we're also going to do the same in relation to people on legacy benefits, recognising the level of disruption that they're experiencing. And then at the conclusion of that paragraph 33, given the Secretary of State's objective, those like the claimants in receipt of legacy benefits were in materially different position. But that only applies at the outset of the pandemic, when a sudden uplift could not be made to legacy benefit claimants. Ceased to be in a material position once it became possible to do something similar for legacy benefit claimants. But that doesn't form any part of the learned judge's analysis.
I'm sorry, this part of the analysis, isn't this dealing with March 2020 and the immediacy of the positions? He does go on, does he not?
I'm definitely not going to avoid it. I'm taking you through every paragraph to make sure nobody can say I haven't looked at it. I absolutely understand the point. He then goes on to say what happened thereafter and what the Secretary of State did. But I'm interested with respect to what the learned judge then did with the evidence before him in relation to that and what he focused on. So paragraph 35, he explains again that the decision in March 2020 was a consequence of various factors. One, the primary consideration was that such a change would not pursue the primary objective of addressing disruption resulting from sudden, and it was hoped, short-term unemployment, and providing greater economic stability. and confidence in the face of grave uncertainty. But that rests on the premise that they would, but for the uplift, suffer greater disruption. But he had evidence before him that that wasn't necessarily correct. But nevertheless, again, I understand, of course, my Lord's point. He does then go straight to his conclusion about the case and whether or not this was a compatible measure. He then deals with the question of whether it was feasible to do it at the outset. And then the paragraph that I believe my Lord's referring to, paragraph 36, when he then goes on to deal with what happens thereafter. The Secretary of State's evidence also addresses how the position of persons on legacy benefits continued to be considered after March 2020, in November 2020, and at the time the annual rating measures were considered in March 2021. And then he goes on to cite that passage. As at November 2020, the decision, including the Chancellor's speech at the annual spending review, was that it was not appropriate to take decisions either on the level of standard allowance or the personal allowance at that point. So no decisions were made. And that's the point made at the bottom of paragraph 36. And then he deals with the March 2021 position in paragraph 37. And he identifies the reasons for the 2021 regulations were materially the same as the reasons for the 2020 regulations. As were the reasons why, when the 2021 regulations were made, the legacy benefit personal allowances were treated differently. Absolutely, he identifies what the reasons were. We understand the reasons were the same. But where does the judge then grapple with justification, having regard to the evidence as it stood? No longer were we dealing with a prospective measure, we were dealing with sustaining an existing measure. That's what's clear from the evidence of Ms. Parker. A measure predicated upon the same assessment about the balance of disruption. We have the evidence at this stage about disability and the impact. We have the evidence at this stage about the camel hump of new applicants, etc. But nowhere does the judge grapple with any of those issues. He stays focused on the reasons given for the measure in March 2020 and identifies them as still being the reasons later on in the year. And then we move on to paragraph 38, where we actually see the substantive conclusion. It says, in considering the case before me, I have in mind what was said by Lord Reid at paragraph 162 of his judgment. All legislation draws distinctions, acceptable of course. The question is whether or not they're compatible distinctions. It says the circumstances in which the decisions to make the 2020 regulations were taken, and for that matter also the decisions in November 2020 and at the time of the annual rating in March 2021, were exceptional. Well, of course that's true, but it doesn't address the underlying point. And then we see, again, making the point that these were obviously political decisions. All of that's accepted, but they're not complete answers to the case. And then we see the rationale. With the benefit of hindsight, it may well be possible to pick holes in the strict logic of decisions taken. But in the circumstances of this case, where the decision challenged was the 2020 regulations was a temporary measure addressing a situation which the government was entitled to regard as one of the national emergency, a sensible margin of discretion must be permitted, even accounting for the fact that claimants' indirect discrimination cases are claimed on the grounds of disability. I'm satisfied that the reasons relied on by the Secretary of State to explain the decision to make 2020 regulations provided sufficient justification. So effectively, what in our submission he's doing there is looking back at March 2020, saying those are the reasons. They identify this anticipated level of comparable disruption. That remains the decision all the way through. That's connected to a legitimate measure, and it's therefore compatible in his view. But it all speaks back to those circumstances in March 2020. He doesn't undertake any inquiry as to whether or not this was compatible having regard to the evidence before him now, which goes fundamentally to...
When you say now...
Yes.
When,
I mean before him in November 2021. He's looking at the evidence.
Once it's all come to an end.
Yes, it has come to an end, and I accept that. I mean, it's only very recently come to an end. But it's evidence which speaks to the impact of this measure during its lifetime. Keeping in mind that in March 2020, they're saying, this is what we see coming down the tracks. These are the assessments we make. We then decide to prioritise Group A over Group B. We then get to court in November 2021 and we say the basis upon which you distinguish A versus B doesn't make any sense. Here's the evidence which shows as much.
Well, you say it only doesn't make any sense in March 21. It made sense in March 20.
Yes, and the reason for that is because of, fundamentally, we accept that in the immediate situation, they weren't able to increase legacy benefit claimants. We do respect and understand that. And we respect the fact that ultimately, measuring what the actual impact of a policy of this kind would take some time. But we mustn't get too caught into the trap here. This isn't about evaluating the quality of the Secretary of State's decision-making by reference to the available that was or could have been available to the Secretary of State then. That's not the task under Article 14. This is not a conventional judicial review. So there's nothing, and indeed we would say, on the contrary, the court was compelled to look at all the evidence before it and say, well, did this judgment in the end reach a fair balance based on everything we know? And that's what we say clearly.
You say that's missing in paragraph 38.
Yes. And indeed, the way it's characterised, that one can look back with the benefit of hindsight and pick holes, in our submission, is consistent with a judge who is, generally speaking, looking at the situation in March 2020, saying this was very difficult. Trying to respond to an emergency, we've got to give them great leeway, and in those circumstances, a very hands-off approach. And of course, we accept that those were demanding circumstances, but they alone can't justify a measure that transpires.
Well, that's all part of the wide margin of appreciation accorded to the Secretary of State, not only in circumstances of emergency response, but also in circumstances where socio-economic, political decisions are being made, for which politicians are accountable.
Absolutely. But it's still always a question of evaluating the evidence, because that may well explain why they had to make a prospective measure based on little information. Fully accept that. But it might be said it's all the more reason to be vigilant after the event to check whether or not those assessments transpired to be correct or in accordance with the evidence. And that's precisely the function we're inviting the court to perform, because if they transpired to be wrong, it's appropriate for the court to say so. And then it's appropriate for the government to look at the situation again, having regard to all of those circumstances.
Can I just ask you something else which slightly puzzled me about the judgment? It looks as though at the end of paragraph 33, the judge is saying that actually those in receipt of legacy benefits are in a materially different position to those in receipt of UC. And that would mean that the question of justification didn't arise.
Well, he didn't find against the claimants, despite my learned friend's submissions on whether or not these situations were analogous. I've taken the end of paragraph 33 to be a direct reference to the content of paragraph 53 of Ms. Parker's evidence.
Okay.
It's all about making a clear statement in March 2020.
Right.
So he's saying, well, you couldn't do that for legacy benefit claimants because you couldn't do anything for legacy benefit claimants straight away. So in that sense, there was a material difference. And of course, we accept that. Our case is one which completely accepts that.
Okay. Let me just make a note about that because I was a bit puzzled.
I mean, just to make the point for completeness, in terms of being in materially different position, it's hard actually to think of how more identical they could be in March 2020, because of course this is the existing UC caseload versus the existing LB caseload. They're effectively mirror benefits that are being one superseding the other. So materially, they're in identical position. All that changes only at the moment that those on universal credit are given the uplift, whereas those on legacy benefits are not. Well, lady, just very quickly on the law in relation to this, you have the extracts in the skeleton argument. We do very much rely on Wilson First County, paragraph 62, as of course endorsed subsequently by the courts on many occasions, including in the famous Denby High School case by Lord Bingham at paragraph 30, which is cited at paragraph 27 in the skeleton. Two observations, if I may, about that. This is not, this principle of law in relation to human rights adjudication isn't solely about when decisions are made and what information is available to decision makers as such, and timing of decisions, which is a point made by the Secretary of State. What they're about is the primacy of the court as being the arbitrator of the value judgment.
Yeah. It's not just analysing whether they went through the reasons
exercise. And that's important because, of course, that then has relevance for the question of what material the court must look at. And it being exclusively within the domain of the court, it wouldn't make any sense for the court to not have regard or disregard evidence simply because it wasn't available to the decision maker. And second, just addressing a point made by my learned friend, we say the principles in Wilson First County are much more a product of that, understanding the primacy of the role of the court in human rights adjudication, than by reference to the living instrument concept. Of course, there may be overlap between those two. Wilson First County may have aspects which are resident of that jurisprudence in terms of living instruments, but the cases, for example, we mention and list at paragraph 33 of our skeleton as examples are much more prosaic. They're not living instrument cases. They are all evidence cases. The government has certain rules, immigration rules, or indeed in the case of Matheson, social security rule, which draws lines, says some people get the benefits, some people don't. Some people are entitled to have their marriage validated in the UK, some people aren't. And the courts then look at the evidence to see if it's justified. And in both Quiller and Matheson, for example, they were looking at evidence in the Supreme Court that wasn't even available to the court below, still less the decision maker. So, as I say, this is not necessarily a perfect analysis, and I accept that. The judge does in relation to one aspect of the judgment made in March 2020 look at how that panned out, the number of people who joined, not other aspects. At paragraph 39 of our skeleton, in very simple terms, we say these are the sorts of things the judge didn't look at, and we say that's explained by his narrow focus. And the items there are listed. I'll just deal with them very, very quickly. There's understanding how that surge worked. That in fact, the vast majority of people had already joined by mid-May 2020. And a period thereafter, they must surely stand to be treated in the same way as anybody else who's relying on the safety net, keeping in mind that everybody else who came onto it would have experienced the same falls of income, etc., whether it was related to the pandemic or otherwise. That there was, of course, the clear evidence that went to disruption about the levels of disruption experienced by disabled claimants, i.e. legacy benefit claimants, and indeed the fact that new claimants were, generally speaking, much better able to cushion themselves against the demands of the pandemic than existing claimants. And indeed the evidence from the Resolution Foundation's economist Carl Hanscom about the experience of being unemployed for people during the pandemic, which he effectively says was very similar in terms of drop of income, in terms of duration of unemployment, to people who, to the normal pattern, effectively. There was nothing particularly special or unique about their experiences. So all of that evidence was there and was all relevant to the question of justification. It was all before the judge and is not dealt with. Just before I move away from the ground, then, what the judge does do at paragraph, get the right paragraph, just give me a moment, 34, is reference the claimant's submissions. He mischaracterises them, if I may say so, by suggesting that they were only focused on the low level of benefits. We do say the low level of benefits was relevant to justification in this case, in a way I'll explain in a bit more detail in a moment. But he doesn't in that paragraph. Potentially, as a consequence of mischaracterising the case, we don't know. He doesn't then go on to deal with what he understood the position to be in relation to comparable levels of disruption during the currency of the pandemic. And then ultimately, just to reinforce the point, when he deals with the question of what he considers to be delay, he then effectively says something he says all the way through, which was this was a challenge to the 2020 regulations when enacted, which it wasn't.
What should he have said in paragraph 34? He should have said, any person required to rely on that level of income will suffer hardship, and comparatively, those who are disabled are just as badly impacted as those who have recently lost their jobs, something like that.
No, the evidence I think would be slightly different, which is it is a culmination of the evidence. The evidence is, and I'm now going into my, obviously I don't know what.
Give us the headlines.
Yeah, he doesn't get the headline points, which are that the comparable levels of disruption tended, in fact, to suggest that new claimants were much better able to cope and experience less disruption as a result of the pandemic than existing UC claimants, and by default, legacy benefit claimants. He doesn't recognise specifically that it transpired that disabled claimants experienced disproportionate levels of disruption by virtue of being disabled. He doesn't deal with the point that the majority of people who were on universal credit as a consequence of the pandemic joined by mid-May, and therefore by January, for example, can't sensibly be described as experiencing a sudden shock. He doesn't deal with the evidence of Mr. Hanscom, which says, well, in reality, their experience was just the same as everybody else who comes onto the benefit system from employment. There isn't really a basis for distinguishing them.
So you said that when he says, however, these matters are distinct from the justification advanced by the Secretary of State, that really built into that's his error.
Yeah.
That he distinguished the objectives of the policy and then looked at those. We can argue about whether he properly looked at them for the duration of the 18 months or
yes.
not. But you say that he had his lens was skewed, that he wasn't really focusing on the right thing. So it goes back to what the objective of the policy was.
Yes, it does. And also the judgments that are made in the lead up to deciding that policy, and indeed continuing with it critically. It's absolutely clear that they could have at some point, we say, increased payments for legacy benefit claimants to take account of this.
Or taken them all away.
Or taking them all away, I suppose. Yeah, that's also an option. Obviously, we would say not, because we'd say that this is a measure that did a great deal to alleviate poverty for people who would otherwise experience it on universal credit, because the evidence before the court, the judge says it's irrelevant. We'd say it is relevant because it must have been a part of the driver for policy, but except that's not how it's framed by the Secretary of State. But for example, just to headline it, the Joseph Rowntree Foundation's evidence is that when they took 6 model families on universal credit, absent the uplift, they would all have been below the poverty line. Now, when you see that the connection that is made by the Secretary of State between the identified harm and the measure is to alleviate the effects of poverty, effectively, mental health, going into debt, arrears, you can see this was fundamentally an anti-poverty measure. It wasn't an income replacement measure in any sensible description. It wasn't going to alleviate the shock. It was just going to make sure they had enough money to meet their basic subsistence needs. When that's understood, that's where the difference between legacy benefit claimants and universal credit claimants becomes extremely difficult to justify.
Can I just run it back to you? I've just made a note to myself. Something along these lines, that you say the Secretary of State embarked on this policy and implemented this policy throughout its lifetime on the basis that it was directed at financial disruption. And the Secretary of State's predicate, you say, was that people who'd recently lost their jobs were the most financially disrupted of all.
Yes.
And that's what came to be shown not to be right. If you're
Yes.
looking at financial disruption, that it was pretty quick, you say, clear that lots of people were very financially disrupted. Have I got it right?
Yes, certainly lots of people, where everybody was, and disabled people were particularly badly affected. So how can that not be relevant to your comparison exercise about relative levels of disruption? So the judgment that was made by Secretary of State is, well, we can see they're going to lose income. We think that's going to cause the most disruption, as opposed to people who are going to face greater prices. So that's an evaluation of fact which justifies the policy, made in a prescriptive manner, which transpires not to be correct. So we simply invite the court to acknowledge that on the evidence that's uncontested before the court. There's no evidence from the Secretary of State that contests any of that.
And is it relevant to all of that? I appreciate everything that you've said, that this was temporary. It would be different if this was a policy measure for the long-term future. We're going to distinguish between these two groups.
Yeah.
But in a situation of emergency, reacting to a pandemic that developed in different ways, I think everybody thought that the measure would come to an end in March 2021 and would not be extended. But it was only the second lockdown and Omicron and all the anxiety and panic that led to this temporary measure being extended for another short period. Is that relevant to all of these questions?
We'd say that goes both ways. First of all, we'd say that when you are in a difficult situation, you're making fast judgments, there's greater scope for getting the judgment wrong. Now, not wrong on the basis of what you know at the time, wrong having regard to what in fact thereafter happens. And as part of the court's role to be vigilant about unjustified differences in treatment, discrimination, particularly on suspect grounds, is to look at that and say, well, totally understand we made that decision at the time, completely see that, but in fact it's transpired not to be a sound judgment. And the question of it being temporary, yes, it's true that quite often when courts are looking at the current state of the evidence, they're looking to remedies which are future-looking, in the sense of, well, we need to change this for the future. And this case is slightly different in that regard, and it's a potentially quite unique feature of it. But I would say this, that for the people who are affected by this, this is a real terms loss of income for a period of time that many people will still be experiencing the consequences of now. If they've gone further into debt, if they weren't able to pay their bills, if they've had to use food banks, if their mental health has been adversely affected, these are all the long-term consequences of leaving people in the situation where they didn't get any extra help despite the levels of financial disruption they experience principally as a question of increased costs. I accept that. And therefore, it may be temporary in that sense, but it's not temporary in terms of its impact. Now, of course, the only remedy we seek here is a declaration that it was incompatible. We've said that declaration should apply from January onwards, and the Secretary of State would then have to make a decision about whether or not she's prepared to do anything about that. We accept that. We accept it's difficult. We accept we're at the appellate stage now. We accept all of those things. But first and foremost, we invite this court to focus on the evidence that's available about the balance that's struck. It's not a criticism of the government to say they got the balance wrong. This is important. It's a valuation of the evidence.
I think what I'm getting at is not that you don't do the exercise. It's that's part and parcel, isn't it, of the proportionality exercise. You look at all of those features.
My lady, okay, let me address that more directly. I say those features may dictate the extent to which you narrow the margin.
Yeah, or widen it.
Or exactly, or widen it. It could go both ways.
Yeah.
But fundamentally, let's just say the demands of the situation at the time, the fact it was going to be a temporary measure, were fully understood and uncontested, which effectively they are in March 2020. but the evidence then shows that there's a clear misjudgment about comparable levels, then it can't trump the latter. The former can't trump the latter. That has to be right.
Okay.
And we do make the point about democratic accountability in this. It's completely different from like a case like SC, where you've got a real clear policy decision. This is how we're going to organise the benefit system. And it goes through all the parliamentary processes and primary legislation. Of course, the Supreme Court go, well, it's just not for us to meddle with that. This is a policy which is done not on the hoof, but as a response to a demanding situation that's produced in an SI, which is a negative resolution procedure. Of course, nobody's going to vote against it because everybody can see the value of having the uplift for the people who need it. So there is no real democratic discussion about that we can reference. And with the greatest respect to the evidence put forward by the Secretary of State here, there's no evidence dealing with any of the material that's put forward on behalf of the appellants. It's all dated in August, early August, and the government didn't choose to file any evidence in response before the hearing in November. And Ms. Parker certainly doesn't deal with issues about the impact on disabled people, etc., or comparable levels of disruption, or what we now actually know about new UC claimants and how well able they were to cope with disruption. None of that is dealt with by the Secretary of State at all. And that's very similar to cases like Quiller and Matheson, where, again, by the time the court were looking at it, there wasn't any substantive response to the evidence from the government on the issue about whether or not the fair balance had been struck correctly.
And in paragraph 38 of his judgment, the judge below really didn't grapple with that, you say. And he really started and finished with, it was all an emergency, which it plainly was in March 2020.
Yeah.
And he didn't grapple with the development of the evidence and the evidence he had before it.
No, there's no consideration of it at all. My ladies, my lord, I've already covered some of the ground that I was going to cover if I moved on to then make some points about my last heading, which is the proportionality issues. In the skeleton, at paragraph 42, we make a number of what I hope are fundamentally uncontentious observations about the law that we ultimately would invite the court to keep in mind if it gets to this stage in the analysis. I'm just going to quickly check if I feel there's anything that's come out through our conversations this morning that I would like just to highlight, if I may. I do apologise, just one moment, my ladies, my lord. Yes, I mean, the court will be very familiar with the ultimate nature of the balancing exercise, but sometimes it is worth stressing what's said by Lord Justice Higginbottom in the Joint Council for Welfare Immigrants case, which is my C, which is that just because you're dealing, at least arguably, in a situation where there's a low margin, doesn't mean you just jump straight from identifying a legitimate objective and saying, oh, it's connected to it. You still have to do that balancing exercise, which is very important, we say, particularly in this case. And at times, the learned judge seems to suggest that, and indeed my learned friend has adopted some of this, that it's not relevant to look at the level of hardship being experienced by, for example, people on legacy benefit payments. We say that's just flatly wrong. It has to be relevant, not least because, of course, as I say, the Secretary of State's justification is based on that evaluation about comparable levels of disruption. Whilst we fully accept at B that there's no mechanical or binary rule about manifestly without reasonable foundation, for example, as being the correct test, we do say that it is very important to keep in mind, as I foreshadowed earlier, the fact that this is disability, it is a suspect ground, and indeed what is said by Lord Reed in SC about why we have this jurisprudence. And
Although it's indirect discrimination, not direct.
Yes, but it applies to both.
It does apply to both, but there's it's slightly less suspect where it's indirect.
Okay, for a moment, let's say
Not a very elegant way of putting it.
Yes,
But you see what I'm not in any way suggesting that it isn't equally important, but it does change the nature of the exercise, doesn't it?
My lady, I suggest that it might in principle, it doesn't really in this case.
Okay.
And I will.
Because you say it's as close to direct.
This is as close as it gets. This is real proxy
Yeah.
direct discrimination.
Okay.
For two reasons. One, because the actual caseload who don't get it are so predominantly disabled. I mean, ESA is a benefit for disabled people. But second, and I'll make this point now because I say it's very important, the justification for this measure is effectively, well, we think we need to give more money to people who were recently working. Now, disabled people who are on ESA accepted to largely be unable to work. In fact, they can work. Some of them do work up to 16 hours a week. But they are excused from the obligations that would otherwise be upon them to look for more substantive work because of their disability, which, of course, is a reflection themselves, not just of their own mental and physical impairments, but unfortunately, the society in which they live. Discrimination, the absence of enough jobs for disabled people, etc. So the social stigma that attaches is very real. So to have a measure which then says effectively, well, we're not going to give you any extra help in the pandemic because you haven't recently been working. We're going to be giving it to the people who have recently been able to support themselves and able to earn, goes to that very critical question of justification. It's a form of double whammy for disabled people. It's confirming the very prejudice that they're experiencing and reinforcing it, both materially and substantively.
Yes, thank you.
My ladies, my lord, I think the other points I make here are essentially there. I just want to highlight those paragraphs in SC where the explanation for having the weighty reasons is given by, it's paragraphs 103 and 112 in the judgment, and it's my point E on paragraph 42. It's to avoid stigma and social exclusion and foster their full participation and integration in society on an equal footing to others. It's recognising that historical disadvantage. So paragraph 43, where we've invited the court to have regard to a number of substantive matters, many of these I've already canvassed, and of course you have the skeleton and the reference within them, so I'm not going to repeat them again. I'm just going to add a few points where I think it's useful to do so, if I may. I think we're doing okay on time.
Yes, we are.
So you have the first point is about the surge and the fact that the sudden impact obviously has to have dissipated over time. The second is about the comparable levels of disruption, and you've got the references there. And you've got the point about otherwise their experiences being very similar. Just on the point about their experiences being very similar, can I just ask the court just to look at the evidence in relation to that, or at the very least the conclusion, which is in Mr. Hanscom's statement. Give me one moment.
137?
137, I think it's paragraph 17, which is the page, yes, 137, I'm most grateful, Marty. So, absolutely recognising questions of scale, more people experiencing this, but the individual experiences are very similar in terms of the duration of employment. And indeed, the nature of the sharp drop-off in income. And then, relevant to that, so keeping in mind that he's saying effectively this, anybody who comes onto the UK benefit system from employment experiences this cliff edge drop in income. It's a common feature. And it was no different for this cohort than others. In fact, may have been slightly better because they had more savings, etc. Similarly, the level of churn of people being unemployed was broadly the same. About 50% are unemployed for 6 months or more, but 50% are not and manage to find employment. But then he says, and while we're at his statement, I think it's useful to take us to paragraph 49, where he speaks to what this measure really was doing and how it should be characterised. And I'm taking to it because it's a useful, I would say, summation of his analysis, which is based in evidence and fact, not his opinion. He says, in this sense, a £20 per week increase to universal credit does relatively little to alter the scale of the income shock individuals experience from losing their job. Instead, it offers a broad-based increase in income to all universal credit claimants and working tax credit claimants. Although it's an obvious improvement, economically the policy is more consistent with improving the overall value of the means-tested benefits rather than acting as a shortcut to providing better earnings-related home insurance. It has made a material difference to the safety net support the benefit system in the UK offers. It has not made any substantial difference to income replacement rates for people who have lost their jobs. Therefore, it's very inconsistent to only apply the increase to UC in working tax credit, but not the other legacy benefits. He's saying on its own terms, when you actually look at what this measure is for all intents and purposes, there's an inconsistency there. And it is why we say that this was, for all intents and purposes, an anti-poverty measure. What it did in real terms is prevent about 500,000 people from moving into poverty. Just want to get you the right reference for that, if I may. Yes, it's in the evidence of Peter Matejicic at paragraph 30.
Well, you reference that in your skeleton, it's a footnote.
Yes,
Yeah.
indeed. I'm most grateful, my lord. Now, it's true to say that it seems that the Secretary of State is keen to disavow this characterisation of the measure, say it wasn't about alleviating destitution. And if we look at the skeleton at paragraph 53...
Your skeleton or the Secretary of State?
My mistake, my lady, sorry, the Respondent skeleton, I was on at page 40. The point that's being made here, to address the other point being made by the claimant, that the new surge happened early on, and thereafter people were effectively in comparable positions to everybody else who's reliant on the safety nets. To say, well, the people who joined UC in March 2020 stayed on UC. In fact, Mr. Hanscom's evidence is slightly more mixed on that. Obviously, some of them did. But what's said is that
the objective of keeping them out of debt and arrears.
Yeah, effectively, yes. So it's justifying the measure there as being essentially what it is, which is a poverty measure, saying you've got enough money now to avoid going into arrears and into poverty. The grander claims for the measure are set out elsewhere. Let me just bring you up those. Paragraph 55, in fact, I think. Now it's described as enhanced assistance to further the community interest by protecting the economy and labour market for when the impact of the pandemic receded. This benefits society in numerous ways, for example, by preserving jobs, improving public morale, increasing long-term state revenues, reducing long-term welfare, and reducing social problems. If that's all ascribed to the purpose of the uplift, in order to try and distinguish it from the effects that would have been a consequence of extending it to legacy benefit claimants, in our submission, that's a somewhat grand appraisal, insofar as it's disconnected from the obvious consequences of trying to avoid people entering poverty, which of course we accept it did do. And therefore it was in that sense inconsistent to that degree with the government's.
So I'm not totally clear what you're. Are you saying that couldn't have been the part of the objective, or are you saying it can only have been anti-poverty, or are you saying she wasn't entitled?
Well,
the Secretary of State wasn't entitled to take that view.
Well, what we're saying generally is a subsistence benefit system which prevents people from going into poverty will have those long-term effects. That's part of having the benefit system. Okay?
Yeah.
But implicit in an analysis which says by giving 20 people £20 more, we trigger all these wonderful benefits. It's implicit in saying that there's something inadequate about the fundamental level of benefits that you're paying because it's not ensuring people avoid poverty. Now, there's no actual evidence to support these grander findings in relation to the £20 uplift. What there is evidence is people didn't go under the poverty line. And we're not for a moment saying that that wasn't a relevant feature of the justification. It's just it would have carried over equally well to people on legacy benefits.
That's your point, isn't it?
Yeah.
That it would have, you can say the same about everybody
Absolutely.
who's on benefits.
There's no real difference. There's no evidence to show that any particularly magic result was achieved other than that by the £20 for this particular group. It's a subtle point, I accept that, but it's going to this point that really we need to look at what this measure actually is and what it actually did, which, as I say, is to alleviate poverty. And implicit in that is because the existing rates of universal credit wouldn't have been good enough to do that. And that's where we say the relevance of the historically low levels of benefit becomes real in the justification exercise. And also why drawing a comparison between these two sets of groups becomes very, very difficult. My lady and my lords, the other points that we make, I think you have all of them on the evidence. So I'm just going to make a couple of observations, if I may now. First of all, our case is not based on a different set of value judgments. It's based on the evidence. We're not saying, oh, you should have pursued a completely different policy for different policy objectives. On the contrary. What we do say is the reasons for distinguishing between these groups don't add up. In that sense, we do grapple with the actual purpose of the measure. And neither are we saying, importantly, that just because somebody suffered some detriment as a consequence of the pandemic, they had an equal right to some assistance to people on universal credit. That's a straw man argument. It's not our case. We're simply saying people in directly analogous circumstances who are arbitrarily on a different benefit system should have been treated the same. But it is perhaps worth pointing out that everybody who was working was on the furlough scheme, if they were lucky enough. Everybody who was self-employed enjoyed an income replacement scheme, and everybody on universal credit, existing or new, got the uplift. In fact, the only people who really didn't get any assistance at all was people on legacy benefits. An anomaly enough in itself, one might say, but when one takes into account the disability component, the disproportionate impact of the pandemic on them, again, set out in the evidence, uncontested, it becomes a stark difference in treatment, which is bereft of adequate justification. The only other point I wanted to raise, I've made the point about the degree of parliamentary scrutiny, etc., is this point about timings and when something could have been done. This just requires a little bit of analysis of Ms. Parker's evidence. Give me a moment.
Is this to do with the annual uprating decisions in November at a time when
Yes.
nobody was intending to extend the uplift?
Yes.
And that moment had passed by the point in March 2021
Yes.
when a decision was taken
Yes.
because of the change in the pandemic situation.
My lady, exactly that.
Yeah, okay.
3 points, if I may.
Yeah.
The first is, just in order to give this its proper context,
Yeah.
the Secretary of State's pleaded case, indeed a skeleton below, is that it was not their case that administrative complexity or difficulties justified this difference in treatment. And we would say in response to that, that must be right, both as a question of law, but also as a question of practicality. Some effort could have been made, even if it couldn't be done in the perfect way. We know that one-off payments, for example, were made to people on working tax credit, and we know that annually a Christmas bonus is being paid to people on benefits for a very long time. Something similar could have been done. Indeed, we've just seen that recently in the context of the cost of living crisis and paying one-off payments to people on legacy benefit claims. So there was that type of remedial measure available. Arguably, there still is. And then the third point, just on this timing, I just want to draw out the evidence just so we're clear about it. It's not abundantly clear to us exactly how this works. And I'll only may be able to clear this point up, but I'm raising it now to give them the chance. But if you look at Ms. Parker's evidence at paragraph 60, which is at page 71.
Page
71, my lord.
here.
First of all, it's dealing with the situation in March 2020. It said it was not operationally deliverable to provide a payment to legacy benefits, as the rates for April 2020, only a month later, had already been input for the legacy benefits system. It could not be changed until the following year without considerable delivery risks. And then said that, again, not possible to change them in year. We would say in relation to that initial statement, insofar as that's correct, it doesn't preclude the sort of one-off payment that I mentioned a moment ago, and it's not said that it would have done in the evidence. And then at paragraph 63, that these matters have also been explained in publicly available material, it said. It said the Secretary of State for Work and Pensions explained on the 30th of June 2020 that an uplift of legacy benefits was not operationally possible. Again, focuses on the uplift. One assumes that's to do a comparable thing with the personal allowance as is done with the standard allowance. But then the explanation given there and the quote from the comments to a parliamentary question don't in fact say that. They don't anywhere say it wouldn't be possible. So the public statement doesn't appear to match that. And then paragraph 73, in relation to the question of timing.
So it says, sorry, before you move on,
Yes.
it says it's can be quickly and effectively operationalised for UC,
Yeah.
but you're saying it doesn't say, by contrast, it can't be effectively operationalised for legacy benefits.
No, and it may have been, and this does appear to be fairly straightforward and obvious that by March it wasn't possible to do something by April. Recognise that. But nowhere does it say there we can't do anything at all mid-year either. Or identify what those risks are, what the possible consequences of the risks are, how serious they are. We don't really have any evidence about that. We're just told what we're told in this statement, which appears to not be fully matched by the public position at the time. And then just dealing with the later position at November. Get this right.
So, I'm sorry to interrupt. I mean, yes, this public statement doesn't set out what the technical difficulties would be, but that doesn't mean they didn't exist. And,
Oh, no,
and have you been making the point, well, the judge had this evidence which wasn't met by anybody else. He also had this witness's evidence, which said, here are all the problems that would arise.
Yes, I accept that. And of course, we're in a very difficult position. We don't know what happens in the DWP. I fully accept that. That's why the two first points I made were perhaps the important ones, which is the DWP has never said this reason alone would justify the difference in treatment. That's important. And second, there are other methods of meeting that difference in treatment which are not covered in this statement. But there was just this timing issue which I just want to be clear about. And it's in essence this, that it said that in November it wasn't clear, November 2020, whether or not the...
Which paragraph are you on?
Sorry, paragraph 73, I do apologize.
73.
Yes.
Okay. I'm sorry I interrupted you, Mr. Bell.
So it said in November 2020, it's not clear whether the UC uplift would be continued. And they've obviously operated on the premise that if the UC uplift isn't going to be continued, there's no need to do anything about legacy benefit claims.
Yeah.
We actually question that as well, if there's already been historic difference in treatment that's not justified. But leaving that aside for a moment, it said that the knowledge about the ensuing pandemic and lockdowns, etc., didn't come until later on, effectively in early January. Reference. So the statement of fact here is, by the time these facts were known and a decision on the future of the uplift was taken, it would not have been possible operationally to include new legacy benefits into the benefit system by April 21. And the earliest date we seem to have for when that became apparent is early 2021. So the facts that would have dictated whether or not to do something, according to paragraph 71, is early 2021. And indeed, another lockdown was announced on the 4th of January. So in November, we don't know, because we don't know about pandemic. But we do know about lockdown by 4th of January 2021. But the order dealing with the uprating for legacy benefit claimants, which of course just increased it by a routine amount, so described, as opposed to the uplift, wasn't made until the 23rd of February 2021. That's paragraph 69. So when you put those three dates together, a little difficult to understand this. Not abundantly clear why a decision couldn't have been made between 4th of January and 23rd of February to lay a different order with a different level of uprating, if that was otherwise desirable. Keeping in mind, of course, the uprating order doesn't have an automatic effect. It has to go through Parliament. It may result in a different outcome, which would require the system to respond accordingly. So I leave it at that. We just simply say that the timings when you put those three paragraphs together seem to create at the very least a question mark about whether or not even a conventional uprating decision could have been made in time for the 23rd of February order, which would have reflected these matters. And of course, this is all happening, the decision about the lockdown and everything's all happening before the government responds to the pre-action correspondence on the 8th of January. Ladies and my lords, I think you have the essence of our appeal. I've got it done in quite good time, I hope. Yes. So perhaps if I need to make any more points, I can do that by way of reply.
Thank you. Anything else? Thank you very much. Very clear and very helpful, Mr. Burton. Thank you. Yes, Mr. Brown.
First, make some brief observations and then respond to the appeal in three parts. Those three parts will be as follows. First, the evidence that was before the court, which explained the rationale for the policy and the justification that was advanced by the Secretary of State. Secondly, the judge's analysis of the legal principles. And thirdly, points in response to the appeal. So just starting with some preliminary observations. The court has heard from the appellant what is frankly a stark difference in what they say policy is designed to do, and what we say the policy is designed to do. My Lady Justice Whipple raises with the appellant by reference to paragraph 34 of the judgment, when the judge expressly recognised and found that the appellant was arguing this case on the basis of, frankly, a different analysis of the policy. And the appellants say that it is a different analysis. They say it is an anti-poverty measure that is at the heart of their case below, and the case run on appeal. We obviously acknowledge that when one is considering a cash-based welfare system, that it is inevitable that poverty alleviation is part of the objectives. That is the whole point of making cash payments to those on low incomes. It will always have a poverty alleviation aspect to it. But social policy as a tool is frequently, and in this case certainly, far wider in its scope and objectives. True it is that it will have an anti-poverty alleviation component to it, but to suggest that that is the only role of social policy would be a very serious misunderstanding of what social welfare is designed to achieve. We say that the lower court recognised and understood that it had a case before it raising complex social policy questions for which there are no right and wrong answers. That remains the position today. It's no part of the function of this court to seek to determine, by way of a retrospective audit or otherwise, whether the government made the right decision, either in March 2020 or March 2021. That's not what Wilson says. That is not the correct approach on any judicial review claim. We all know there will be a COVID public inquiry in due course, which is going to consider multiple aspects of the pandemic and take relevant evidence. And a time will come when there is cause to consider what was effective and what was not. The government's firm position is that this measure was effective, but the only question for this court is whether it was lawful, and we say it plainly was. Further preliminary observations. It is not merely the fact of the pandemic, but it is also the nature of the measure under review which goes to the question of margin and latitude. It is right to acknowledge, though, that the margin in the context of a decision such as this should be exceptionally wide. The balanced approach which the judge took to margin is the correct approach. The judge correctly identified that he had before him a case of disability discrimination, but it was indirect. Indirect discrimination, my Lady Justice Simler indicated to the appellants, is something which, generally speaking, has a lesser affront to human dignity. Not always, it all depends.
Not always, and
Yes.
there are different levels of indirect.
Indeed.
And here the point being made is that it's as close to direct as can be because the proxy is so clear.
Well, the proxy isn't as clear as all that,
Is
but
it not?
I'm prepared to accept that, broadly speaking, when the legacy cohort proxy has a greater representation of disabled people within the cohort, I accept that. And therefore, in circumstances where they do not benefit from this increase, then in that respect, there's disparate impact which falls to be justified. But one has to consider other aspects of the legacy benefit scheme as against the universal credit scheme to consider how far that goes. And one of the points that we have made throughout is that legacy benefit claimants were entitled and have always been entitled to claim universal credit. If they wish to have the advantage of the universal credit system, including the payment levels, then they can simply claim it.
Well, you say they can simply claim it, but
Yes.
there were difficulties. One of the appellants was told they couldn't. I think it was appellant number 4.
Yes,
And for others, there were waiting times and difficulties, weren't there?
but those are structural aspects of universal credit.
But,
Th-
but
this
it's
is-
a reason, a perfectly rational reason why they didn't claim
Yes,
it.
absolutely, and I'm not suggesting that there's not perfectly rational reasons not to do that, but one has to be careful about the problem of cherry picking, which is saying, well, I would like to have this aspect of the universal credit scheme, i.e. a temporary additional increase in payment, but I'm not prepared to take all of the other aspects of the scheme that go with it. So I don't challenge the individual evidence.
I don't think they want this bit of the universal credit scheme. They say, we want the same payment as people on universal credit.
But they can have it. They can claim it.
Well,
So there is, respectfully, cherry picking here, because one has to bear in mind that there's all sorts of other factors. I'll show the court the evidence insofar as it's relevant. It's not a central feature of the case, but the conditionality aspects of the two systems are different, so that the nature of the obligations that go with receipt of the benefit are different. And indeed, as the court puts it just now, there's differences in terms of how one actually goes about claiming and the initial waiting period. And I accept all of that, but one has to bear in mind then, and it goes to the question of whether they truly are in comparable positions, which in turn goes to justification, is that in fact they're not actually in all that a comparable position, because the nature of the two benefit regimes is fundamentally quite different. Now, the judge didn't dispose of the claim on that basis. He didn't say you're not actually in a relevant.
that's the point I was seeking to make.
My lord, I agree, but it feeds into justification and margin then in that case, because if one is in a very closely aligned or similar position, then justification is potentially, the margin starts to narrow. If in fact they're not, and the comparability is fairly broad brush, then that points alongside other factors towards a wider margin. It's a fairly conventional approach, we would say. If one is going to accept, as this judge did, that he's not going to dismiss a claim on that basis or on the basis of status, then it feeds in. It has to. So turning to the evidence, and I do say it is important to have proper regard to Gersten Parker's witness statement in particular, because true it is the claimants filed evidence. It's not expert evidence. They didn't have any permission for expert evidence. They had statement of fact evidence from, obviously, the claimants themselves, and then academics setting out aspects of social and economic policy which are impacted by the decision. But all of that, we say, goes back to effectively the cardinal error in the case, is that it supports a different social policy objective from the one that the government was putting forward. So it's an unusual case when we put forward our answer in terms of justification in our detailed grounds and in our written evidence, and we're told by the claimants, no, that isn't actually your social policy. How do I answer that? The government's clear position is that it is our social policy, because the witness who speaks for the Secretary of State is telling the court that it is. And this is a judicial review. The general principle is that one takes the defendant's evidence at face value. And we invite the court to do that in the way that the judge did. But if I can just make some further observations by reference then to Ms. Parker's written statement, which you have, supplemental, tab 7, page 50.
Yeah.
So I appreciate the court's read it very carefully. So the court would have seen then that the witness is Deputy Director of Universal Credit Policy, so responsible for universal credit policy, see paragraph 1, authorised by the Secretary of State to make the statement. And then paragraph 2, the witness explains that it is part of the government's response to the pandemic. So it is not the case that the government has decided in March 2020 that this is the moment to meet the challenges of poverty, which of course is a long-standing feature of society. It is obvious, we say, that in March 2020 the government is reacting specifically to the challenges that are faced by the pandemic. And those are challenges which interact with poverty. But it is wrong to say that in March 2020 the government's priority or general objective is to introduce a measure which has at its heart the objective of the alleviation of poverty. Then paragraph 3, witness explains 2 of the 3 features of the policy. So as to why the Secretary of State was not prepared to uplift raw. First is that it's undesirable when one properly understands the policy objective. And second is that it's inefficient and impractical. So as my Lady Justice Whipple put it in the course of argument, there's effectively 3 limbs to this. The first is cushioning, for want of a better expression. That is the limb. Second is practicality of delivery. Third is messaging. Those are the three limbs that one sees throughout the evidence. And when one properly understands what that means, one sees that it's not just about general adverse impact upon individuals who are in receipt of benefit. So the cushioning logic, one has to, for the sake of this judicial review, one has to accept the logic of it because it's the government's decision. The logic is that cushioning is critical because it is cushioning the impact of those who are new to the state of affairs in question. And that's not just generally claiming universal credit because of unemployment or reduction in employment. It is doing that alongside a very large number of other people. So it's the challenges of collective mass unemployment that need to be cushioned. And that's what the government has very firmly in mind. And that was revealed by the statistics. That's exactly what happened. So the 3 million became 6 million. It would have become much larger were it not for the related measures, namely furlough and the self-employment support scheme. But all of those policies are designed to work in conjunction with each other, reduce the effects of the pandemic upon the labour market, to ensure that the labour market effectively becomes resilient, that it is able to return back to employment as quickly as possible. And that benefits not just the individuals for the reasons given in the evidence, it benefits the economy because there is then a pool of labour available, and it affects society. So high-level macro judgments which were ultimately vindicated. And they're not undermined by the sort of analysis of the statistics which the Appellants urges on you, which is to suggest that, well, there weren't actually that many new claimants after month 2 of the pandemic. That tells you nothing at all, because the overall volume has doubled from 3 million to 6 million. And that was the concern that the government had in mind. So it's not about a run rate of new claims, it's about overall volume of claimants that's critical for this. The witness explains then in some considerable detail from paragraph 6 the various differences in the social security entitlements in question. And this, again, further detail in response to my Lord's question, they are different benefits with different qualifying criteria and different entitlements that flow thereafter. So you see then what is said at paragraph 7 to 9, different benefits, different rates, different entitlements, and what benefit one is entitled to receive results in a multiplicity of rules and consequences in relation to other aspects of social security, taxation, income, etc. And the general principle is that there just is no rule that a change in entitlement or a change in the criteria for one benefit automatically has to feed into other different benefits, notwithstanding that they may achieve some similar general high-level objectives. There's never been a principle of social security that if one makes a change to one benefit, one has to feed it into another. Don't need to go through all of the...
But there is a principle that if you administer a benefit system in a way that indirectly discriminates on suspect grounds, there must be justification for that discrimination.
Yes.
Otherwise, it will be unlawful.
Absolutely so. You would generally find that within the framework of single benefits, so individual benefits which have discriminatory entitlement criteria. I took a point below that one doesn't see it when one's comparing different benefits altogether.
Right. But the judge didn't accept that.
Well, he didn't
Or
say
he
that
didn't
it was
deal with it.
not determinative of
Yeah.
the point. And again, this really goes back to my, well, how similarly situated are they point. So the fact that it is different benefits is plainly a relevant factor, and it ultimately all goes back to justification. So I accept the point that my lady's just put to me, broadly speaking, of course, any benefit system has to be non-discriminatory in the correct analysis of that term. Here, I think the point is really more responsive to a point the appellant made, that there's a history of social security tradition in this country, which is that which universal credit has built upon, and which has always meant that uplifts go hand in hand, effectively, between universal credit and what went before it. And we say, well, that may have been true, and it may be right that that historic link was broken in March 2020, but ultimately that's legally irrelevant, because it's open for the government to break that link if it thought it was appropriate to do so. So then 28 to 29, witness explains universal credit, makes the point that actually even this £20 per week is not sort of hard-edged, because it's in the nature of universal credit, as will be familiar to the court, is that it interacts with other earnings.
Yeah.
So you don't actually inevitably receive £20 in one's pocket in the way that the legacy benefit claimant cohort would expect to.
Other earnings and savings.
Yes, exactly. So it interacts with primarily earnings, but because it fluctuates as a result of fluctuating earnings, and savings too. And 29.6, claimant commitments, is one of the points I made before. So it is part and parcel of universal credit that a claimant makes a payment commitment which is tailored to individual circumstances. These are features which are not present, at least to the same extent, in legacy benefits. In paragraph 30, the numbers, so the witness was explaining both the original rationale and to some extent what happened. So there was indeed a large increase. And it was a very rapid increase, so 3 million to 6 million, following lockdown, notwithstanding furlough, which was designed itself to protect employment. And paragraph 31 responded to the specific circumstances of the claimant. The claim has always been effectively a systemic challenge to the overall scheme, so one would ordinarily approach it on the basis of the overall scheme as opposed to individual facts. That's the principle in Carson. And in any event, though, the witness does explain the response to all of that. Broadly speaking, though, the factual challenges are all well known and understood, but there's mitigation in place to assist. And indeed, in due course, the whole population will be transitioning to universal credit. So it will not be an answer to say that somebody wishes to remain on legacy benefits. They have been abolished. Moving then, please, to paragraph 40. Then just focus on the three key principles which govern the policy response. So, point one, the main focus on support was support for the labour market. So this is an important aspect of our case. We say that the measure was designed to intervene by reference to support for the labour market as opposed to poverty alleviation. That is clear when one puts this alongside the furlough scheme and the self-employment scheme. One can see that all three of those measures are directly focused upon the labour market and ensuring its robustness and the economy so as to allow for a rapid bounce back. Second point, the measure was focused upon delivering what is possible. Paragraph 42. So here, ultimately, the decision that faces government in March 2020 is that it knows it has some infrastructure, namely the new investment in universal credit technology that allows for this to be done rapidly. And it knows that it does not have that same infrastructure available for legacy benefits. Now, if the government didn't have that infrastructure for universal credit, then the real question would have been, well, do we do anything at all? Because the evidence that the witness gives is that there's considerable challenges in terms of IT delivery. Those are all exacerbated by the challenges that are facing the department itself in the teeth of the pandemic. The department itself is affected by staff absences. It has to roll out a potentially complex and difficult scheme in the face of its own challenges. It can only do it because the universal credit infrastructure allows for it to be done in a way that's reliable. So that's,
But each year that when uprating decisions are taken
yeah,
in relation to the legacy benefits, they are then implemented at the beginning of the financial year
Yes.
safely and efficiently.
yes, so the decision was taken in November. In fact, what was suggested to you was some lack of clarity in the evidence. Is perfectly clear, as I showed in a moment. The computer systems are, the inputs in the legacy systems takes place in November.
Yes.
Yeah.
So that it may not have been possible in March to do
Yes.
it safely and efficiently.
Yes,
But you might have been able to do it in November had you chosen to.
absolutely.
Safely and efficiently. That was my only point.
Yes, and that point is acknowledged and accepted. If the decision in November had been to do it, it could have been done. Different point made by the appellant, well, couldn't you just do something else?
Yes.
Well, it's a discrimination challenge. They're claiming that they should have the same £20 per week uplift built into their legacy benefit entitlement. So it's not an answer to say, well, you could just give us £500 or something of that nature, because that takes it away from being a discrimination challenge. It then just becomes pure policy making. They're saying, well, okay, we accept all of your rationale on implementation, but just do something else. Then, third point, focusing on those likely to face the most financial disruption from the start of the pandemic, so cushioning and adopting a flexible approach to the way that benefits are administered. This means targeting support of those who've lost income as a result of the pandemic, rather than those who may have faced increased costs, which could not have been accurately calculated by the government.
That's the key, isn't it? That's your answer, isn't it?
Yeah.
I'm getting ahead of you.
No, you're
I'm just
absolutely
trying
right.
to see where we are, trying to fit the policy in.
Yeah,
But it's the point about financial disruption. That's the key to this. It was
Yeah.
people who were moving from. So in fact, they were quite a relatively speaking well-off group of people because
Yeah.
they'd been in work. They weren't people who had historically needed to rely on benefits at all.
exactly.
But that wasn't. But your group of universal credit claimants who would get the uplift would include a significant number who weren't
Yes,
facing that
2
financial
points there.
disruption.
First point, Mally's absolutely right. It's not targeting what some might say is necessarily the most financially needy. It is targeting those who have the initial disruption to their income as opposed to their outgoings. So even accepting the logic of the claimant's evidence that actually our overall financial position is affected to a greater degree because our outgoings are higher, that's not the point. This is about the disruption caused by a significant reduction in income. Malay is absolutely right. There'll be some high-earning people who will be entitled to claim universal credit because they lose their job. And it is that which the government is looking to target and protect and cushion, because it wants those people to go straight back into the labour market as quickly as possible. And that hard logic simply does not apply to the cohort that the claimants represent, because they're not in the labour market. So,
No, I mean, that is the double whammy point. That
Yes,
they're not in the
absolutely.
labour market.
yeah, absolutely so. So one can see that the force of the political point that is made, but it is that because they are saying, well, look, we too are deserving for completely different reasons. Namely that we have always faced the challenges, and what is more, we are now doing it with all of the additional challenges of the pandemic and what that's causing to our cost of living, etc. and all of that is known and understood. But the question is, well, should social policy meet that particular need, accepting that there is a need, or should it meet a different need for different reasons, because those reasons will have a greater benefit to society because they will protect the labour market and the economy. The government made the choice, right or wrong, that that is the priority that the government was going to adopt at the relevant time.
I don't. This is all March 2020.
Yeah, March 2020, yeah.
Which is not a subject of challenge.
But the point is, it's a 12-month decision. So this is where the Wilson point, I think, starts to become rather difficult, because Wilson doesn't say anything about what one does looking back at what was always a time-limited decision. So it's a time-limited decision based on judgment in March 2020 as to what was likely to happen. That judgment was largely vindicated in from the government's perspective. So they introduced all of these measures at vast public cost.
I'm sorry to interrupt. I'm sure you're right about all of that, but you're emphasising a point which isn't disputed.
But one can't. The March 2021 decision isn't taken in a vacuum.
Yes, I understand that.
Yes.
But I mean, you obviously take your own course. To think we haven't read that and understood it and appreciated it, and indeed has been acknowledged by the appellants, I'm not quite sure why.
Like, I can't get to March 2021 without taking the court to March 2020.
Yeah.
Because it's the logic of our case is to say, well, they say, well, material change in circumstances. That's broadly what the claimants argue. So we say, well, if one properly understands what the objectives are in March 2020 as opposed to what the claimants believe they should have been, then one sees that exactly the same rationale applies through to March 2021. And what is more, the government has the benefit of knowing that the decision taken in March 2020 was economically sound to achieve the objectives in question. So it did what the government wanted to achieve. March 2021, it then or indeed January is when the actual decision was taken. Yeah. The government has to decide, well, we were going to bring this measure to an end because, frankly, the cost is significant. However, we are now in the face of another lockdown 2 or 3, whichever it was. Question, what do we do? Do we proceed to let it run its course and come to an end? Or do we do something different? Answer, well, we'll do something different. We'll have a 6-month further extension because we know it's been a successful measure in achieving all of those social policy objectives which we identified in the first place. So it is artificial for the appellants to come into this 12 months along the line and say, well, we're content so far with what the government has done, but we now assert that you've got to do something different because it doesn't further our different social policy goals. Because we say, well, we don't share your social policy goals, we understand them, but respectfully, they're not the social policy goals of the measure. On the basis of what we say the social policy goals are, it's perfectly obvious that there's a rational decision which would justify a 6-month extension. That's what it comes down to. So we do say one has to do what the judge did, which is understand why it was there in the first place, and then follow that through. How else does one approach this? I don't think I answered my lady's question. Some get scooped up, and they do. But that just goes back to effectively the implementation limb. So the fact that some people who have claimed universal credit possibly some time ago are not the immediate beneficiaries of the first limb of the policy is true. But they're caught up because of the second limb, namely doing what is operationally achievable. Because the alternative to doing that is to somehow try and then actually decide on the facts of individual cases, well, are you within the rationale? Or should we just extend this only to people who presented a claim between certain dates? But all of that has to be done at a time when all of these operational challenges are immense. So much easier simply just to roll it out to everybody who claims universal credit, knowing, as the government does, that if some other person with a long-term disability wishes to bring themselves within that cohort, they can do it, they can claim.
When was the extension announced?
March 2020.
That's when it was implemented. That's
it
when
was-
the regulations came into force. But was it
Yeah.
announced before?
It was March 2020 it was announced. I'll show you the.
No, I think the question was, when was the extension?
I'm sorry, the extension.
Yes.
Yeah, so that was all. Let me remind myself, I believe that was shortly before in March of 2021, but I'll double check. I apologise, I misheard. So, the witness then, from 47, makes the point about other measures that assist the circumstances of those in receipt of legacy benefits. Then 48.
Well, what's the relevance of that? That's irrelevant, isn't it?
Why?
We're in a situation where there are two groups who
Yeah.
have been found to be sufficiently similar to warrant a conclusion that there is prima facie indirect discrimination.
What's the relevance of me saying it now?
Yes, what's
No,
the
I'm not
relevance?
making any submission on it. I'm
You
just-
drew attention to 47, sorry.
apologise.
I just
I
wanted
was-
to know why.
No, I was going to say, I wasn't making any submission on it. I
Oh,
was
sorry.
simply,
I've misunderstood you.
no, my
Where are,
lady's
we, where are
right.
we next?
I wasn't going to try and advance any other argument other than
Good.
the one I'm making now.
Yeah, good.
Okay, 48.
Yeah.
The witness deals with issues in further detail. Consideration. You might fairly ask me the same question. Well, what does it matter about whether the government thought about the position? But to some extent, it's not irrelevant.
No, I accept that there is some relevance to the
Yes.
fact that the government confronted the
Exactly.
difference.
That is precisely the point. So this is not a case where the government did not understand the nature of the hard choice it was making. It did, and it confronted it, because that goes to margin. Frankly, everything in this bill only goes to margin, but that is another feature which plainly goes to margin, is that the government has thought about this very carefully, thought about the points, but decided it's not the right course. And we'll see that then, paragraph 50, not about meeting cost. And then 51, 52, 53, which really does crystallise the three limbs of the policy. So, if I may, I won't read them out, but I asked the court to read 51, 52, and 53, which of course already read it. In 53, the messaging, the morale point is difficult because it's not a hard-edged point. But it is a significant point because the government doesn't know what the response of society is going to be to the pandemic, or indeed to the measures that the government is implementing. But it has a connection in the view of the Secretary of State and the Department for Work and Pensions to other aspects of the policy, namely the morale aspect. Because to a large extent, the social policy objective of preserving the labour market and preserving the economy is about confidence. It's about ensuring that people have the confidence to know that there will be a bounce back, they will be returning to work, there will be jobs there for them. And that has to be done in a way that's comprehensible. And this measure is designed in a way that achieved that. So fixed sum, £20 per week, simple to understand, indicates to people in a time of particular need that there is support. Not an indemnity against need, indemnity against costs, or an indemnity against lost income. It is assistance. And it is designed to provide that messaging. And that's the government's view. And 55 has more detail then about consideration point, and we do say it's an important constitutional point in circumstances where the government has carefully considered all of this. And the objection for it is essentially at paragraph 57. Then 58, when it explains in more detail what the rationale of the cushioning point actually is from the expert perspective of the DWP. So sudden and short-term unemployment is capable of triggering other social problems and affecting mental health. This can result in a situation in which a person becomes dependent on welfare and hamper return to employment even where there are vacancies. These effects are likely to be exacerbated by the pandemic. It follows that seeking to prevent these social problems from arising following sudden unemployment can benefit individuals and society. And then the IT constraints, which I believe are reasonably clear to the court. So there are these IT difficulties. And we are entitled to say that that's a relevant factor. Not immediately clear why we wouldn't be able to make that work. We're talking about the infrastructure which is in place for the entire country. And if it is not able to deliver the sorts of alternative policies which the claimant is promoting, then that is itself a powerful and sufficient reason for not doing it. And the witness is saying it's not operationally deliverable, not least because of the pandemic. So it's not an answer for the claimants to say, well, that's your fault, and just fix it, because that is not the evidence. It just can't be done in that way. Then see paragraph 61, not feasible, posed a danger to the whole system. The decision prioritised the safety and stability of the benefit system overall.
So this is all as at March 20.
Yeah.
Yeah.
Then, just because they're convenient, deal with points that are raised then. So, paragraph 63,
Yeah.
it should be a health warning. That is a question in Parliament and an answer in Parliament. So, not strictly, or indeed unstrictly admissible, but it's there. We don't quarrel with anybody relying on it.
Well, you put it in your own evidence.
We did.
It would be odd to quarrel with it.
I know. It depends what one's doing with it. That's why I say it's really a health warning in terms of treatment of parliamentary material. It's not always objectionable. It can be used so long as it's not being used for an inappropriate purpose.
What was your purpose?
What was the witness's purpose? I frankly can't recall, but
Well, anyway, it's there. I
Yeah.
don't think it's going to be profitable for us to look at the purpose. It's there. You
no,
put
but
it in.
insofar as
And it doesn't, as Mr. Burton said, explain that the legacy benefits couldn't be dealt with in the same way by virtue of operational and IT system problems.
no, but the witness explains all.
She does, yes.
Yes. So
that's-
I take the point. At the bar, one can always pull apart these answers, but it's not really the purpose.
Yeah, okay.
It's
Well,
perfectly
there it
obvious.
is.
Yeah.
Doesn't matter.
Okay. Right. 65 then.
Yeah.
Consideration in autumn 2020 of whether to maintain the UC uplift and make an uplift to legacy benefits.
So this is the point at which you could have effected operationally an uplift for the legacy benefits.
Well, my lady puts it in a fairly stark way. We're not saying that it was impossible either before or after. What we were saying in March 2020 is that the risks were...
Yes, but all I'm saying
Yeah.
is at this point, the operational problem
Yeah.
wouldn't have been an impediment.
Um,
If you'd wanted to do it then, that's the time that you thought about the uprating, and you could have done it then.
yes.
That's all I'm saying.
No, and I accept that, my lady.
Okay.
So there's an uprating review that's happening anyway.
Yeah.
So effectively, there could have been the index-linked review followed by just an increase of
Yeah.
£20. Yeah,
That's really all I'm saying.
no, absolutely. So that much is acknowledged. Then paragraph 65. So the timing is
Well, and at this point, the government weren't even sure what they were going to do about universal credit.
correct.
So there wasn't, in a sense, you thought about whether you thought about legacy benefits or not. You weren't actually thinking of uprating universal credit again after March 2021.
Absolutely so. So
Yeah.
the government's position is that it knows that the measure is coming to an end. So in a sense, this is the only logical decision, if certainly in the context of discrimination, is that the discrimination will cease as of this point, because the government knows it's going to come to an end in March. So the idea that one would then introduce something for legacy benefits, which is not actually going to then be the case for universal credit from March of 2021, it would have no logical connection to the government's policy rationale. So yes, it could have been done, but that would in no sense be achieving the policy objectives, and there's no other obligation to do it. So the claimants can't say that benefit levels are just low and therefore we should have an increase. So the position is perfectly clear in November 2020. Namely, it's a review, and it's not implemented. And then see paragraph 66. So it's all under consideration. I mean, nothing's off the table. The spending review statement of the then Chancellor is explaining what it's going through to next spring. And then he says, well, we'll look at it. So that's the position. The government hadn't ruled it out, but certainly wasn't positively proposing to do it. And then what happens is a matter of historical record, and indeed we'll all recall, is that the circumstances deteriorate. So paragraph 67, highly evolving situation, huge amount of financial investment. One's going to do something, it should only be done when the circumstances justify it. And in autumn they didn't. Then, at the bottom of page 25, the witness makes the point which answers the appellant's issue before, because they say, well, the uprating order wasn't laid before Parliament until February of 2021. But what the witness says in clear terms, 4 lines up, in relation to legacy benefits, the process of inputting the rates into the IT system for the following year needs to take place several months in advance. The rates to be paid up to March 2022 had to be programmed from November 2020. That would not have enabled the government to respond to rapidly evolving demands of the pandemic with the latest and most accurate understandings of the situation. So it's not about putting the order of the statutory instrument before Parliament. That doesn't take any time. It's about what needs to be done in order to actually implement the payments that's relevant here.
Well, that's what the last sentence in paragraph 69 says.
Yes.
The SI is simply an SI. The decision was taken in November 2020.
Exactly. So that's 68. No decision in November 2020. 69 was the standard uprating review from the SI. And 70, no policy reason to change the rationale. So that's November. Then this is directly then what is challenged, because up until this point, no criticism of the government. Then 71, deterioration, this time 2 years ago. And then 2021, lockdown, 4th of January. As a result of that, there is further opportunity to act, but it's a different decision, temporary extension for 6 months, see paragraph 72. And it is the same rationale, and it is in respectful disagreement with the claimants about how significant the effects of the pandemic were at that time. See final sentence of paragraph 72. As the pandemic and its effects were continuing, it was not considered an appropriate time to withdraw that support. Because the logic of the appellant's position is that the pandemic has receded. That we say, well, factually disagree. This isn't a hard-edged point of fact anyway. This is a question of judgment as to what's happening with the pandemic. But the position as it stood in early 2021, the government's perspective is we're about to go into lockdown. That is not consistent with the pandemic proceeding. Secondly, it does not follow, even if the appellants were right, that what has to then be done is to introduce a 6-month extension of support for both cohorts. Because one can assume that the government, had it taken the view that the effects of the pandemic were receding, would have done what it did later, which is to allow the measure to expire and to remove the differential treatment that way. And that demonstrates that this is, we say obviously, a measure designed to mitigate the effects of the COVID pandemic rather than some broader anti-poverty initiative. It's the reason why it was done in the first place, and it was the reason why it was extended thereafter. Then 73, point about not knowing what would happen in November. Then at 74, as to the extension, the reasons match the original reasons for the UC uplift, which I addressed above. The point I made before is that one has to, but for government to say, well, broadly speaking, the same rationale, one has to understand what the original rationale was. And all of the points that have previously been identified held good 12 months later. Then 75, even if the IT problems could have been overcome, would have been undesirable, because it just wouldn't have met the social policy objective. So that's Ms. Parker's evidence. You also have Lindsay White's evidence. Perhaps don't need to take that, take you through that in the same detail. It's really just dealing with broader measures, broader government decisions about what else it was doing to support the general cushioning objectives, supporting of the labour market and the economy. And that witness, for example, deals with the fellow scheme, self-employment scheme, and provides evidence from an economic perspective about the concern to ensure cash flow, business failures, etc. And the witness also makes a point which no doubt is obvious, that we're talking about very large sums of money. And that means that the actual decisions need to be very carefully considered. That's what I'm proposing to say about the evidence then. The judgment the court has been shown, if I can just make my responses, submissions as to why we say the criticisms are not well founded. So the key passages in paragraphs 30, 38. So the court clarified with the appellants that they don't attack the judge's approach to margin in general terms, i.e. it is multifactorial. It's not, there's no dichotomy between weighty reasons, manifestly without reasonable foundation. All of that's been swept away by SC. What one has is an approach that takes into account all relevant factors, applying an appropriate margin in light of the measure under review and all other circumstances before the court, and that's precisely what the judge did. So see paragraph 29, and he correctly directs himself that not only is it social and economic policy, so already one is in the wide margin, but it's social and economic policy in the face of an emergency.
Yeah.
So it's difficult to imagine a case where there is going to be any wider margin. Then 30, the judge set out the reasons, so accepting the evidence of Ms. Parker, and in accepting Ms. Parker's evidence, he necessarily then did not accept the claimant's evidence from various professors as to the different social policy objectives that they say the government was looking to achieve. So, we say unsurprisingly, the judge accepted that the the Secretary of State's rationale for the disparate treatment was what she said it was, not something to be found in the claimant's witness statements. Then, 7 lines down on page 96, in paragraph 30, the sentence, "This group would face particular disruption as a result," which is really at the heart of everything, because we've got a different understanding of what disruption means. Because the appellant says disruption means our outgoings are going to be greater, and it's the double whammy because we're already the most vulnerable in society. So yes, that is properly described as disruption, but it's not the disruption in issue. The disruption in issue is completely different. It's the cushioning on people who are going into unemployment for the first time. So it is that point which the appellant really seeks to make a lot of, and suggests that if it's just about disruption in any sense of the word, then the logic of that would bring my cohort within the scope of the policy. But we say, no, you've got to understand the evidence properly. It doesn't just mean any disruption. It means the specific disruption that the policy is designed to meet. And the judge accepts that, talks about the fact that there was indeed an increase. So the projections turned out to be, well, who knows whether they're accurate. Certainly the judgment that there was going to be very substantial impact to the labour market, that judgment was accurate. Then 31 accepts the logic of the policy arguments. So yes, assuming then that all of the components of an Article 14 claim have so far been made out, i.e. that there's sufficient comparability, etc. So there is disparate treatment that calls for justification. Was it lawful for the Secretary of State to treat in that disparate way, i.e. by focusing upon those who've made claims for universal credit? The judge says, I consider that she was. The benefit claimants would need to adjust to a loss in income that be affected differently to persons already claiming benefits, given the objective pursued by the 2020 regulations and circumstances in which decisions to make those regulations was made. Legal scrutiny of the decision to make the 2020 regulations must allow a degree of latitude. All this being so, the distinction between the legacy benefit personal allowances and the universal credit standard allowance consequent on the 2020 regulations rested on sufficient reason, and that is the reason that we've offered. So far so good, still needs to say, well, does that rationale still hold good 12 months later? So the judge at paragraph 32 accepts the further evidence about the technical difficulties and where the line is drawn. And the judge accepts the point that even though some, so final sentence 32, the fact that others also benefited does not go to the legality of her decision, and that is right. Doesn't make it unlawful that there are some who benefit who are not within the primary scope of the policy.
I think just going back to 31, if I may, I'm so
course,
sorry,
yeah.
Mr. Brown. I think the point made by Mr. Burton was that the judge didn't look at whether what happened justified that conclusion.
Yes. So one has to bear in mind that this is a predictive judgment case. So
It was predictive in March 20.
Yes, and it's also predictive to some extent the following year, because no one knows whether in fact the pandemic is going to carry on to have the adverse consequences for the next 6 months. And the government's view, based on what's happening in January, that it's still going to be creating social problems that have been described well into 2021. So that it is also a predictive judgment, but it's informed by a safe judgment or a safe analysis of what's happened before. But the only point in March 2021 is this: the government looks back at the past 12 months and says, well, was I right or was I wrong? Turns out I was right. So there's very substantial impact to the labour market, as was anticipated in March of 2020. Do I believe that my measure made the sort of difference that I intended it to do? Or did it do that in a way that justifies a very significant cost? And the answer is, well, yes, I do think it did that. Nobody knows on individual cases, but one has to look at the macro position. But the appellant's real point here is they say, well, looking back, should you not have appreciated that my cohort were also in very difficult and challenging personal position?
Yeah.
But I mean, that was known at March 2020 as well. I mean, nobody was under any illusion about the extent of the challenges that would be presented. And it's inevitable that those sorts of challenges are going to impact the hardest on individuals who are vulnerable in society. That is well known and understood. The appellant's absolutely right to make that point. Well, we are that cohort because we present disabled people long-term subsistence benefit claimants. So if you're talking about challenges that are going to be faced by all, clearly they're going to be faced by us to a greater extent. And that is right, but they are different challenges. And the argument as to what the government should do to meet those challenges is a different one. And it's one that's not before the court. Because the appellant's short answer to that is, you should be increasing welfare spending.
Yeah.
And that's an argument that's proper to Parliament. So, Judicial 33 deals with Parker's evidence 53, so the messaging point. I take my lady's point about the sentence just under the point extracted. In fairness to the judge, he really is approaching the case or determining the case on justification.
Yes, he is.
Yeah.
But as you said, it feeds in.
Yeah. Then 34, again, the disruption point. And it's the final sentence, which is critical, because the judge says, correctly, these matters are distinct from the justification advanced by Secretary of State for the decision to make the 2020 regulations. And they are distinct. We come back to that.
Because they're about the poverty and the hardship.
They're about poverty, alleviation. They're about the different hardship challenges that face the cohort in question. And 35 deals with our evidence then about the various considerations that go into all of this. And 36 deals with the evidence that continues, so updates the position. So it's plainly wrong for the appellants to say that the judge has not properly considered the evidence that I've taken the court to about the ongoing nature of the decision-making process. Because the judge says at 36, Secretary of State's evidence also addresses how the position on persons on legacy benefits continued to be considered after March 2020, in November 2020, at the time of the annual rating measures, and in March 2021. And then records the evidence about, first of all, the November decision, then at 37, the decision in March 2021 to make 2021 regulations extending the standard allowance uplift was a further decision resting on political judgment. Late 2020, restrictions on the economy have been reimposed. In the early part of 2021, these measures continued, and the precise course of the pandemic remained unknowable. The reason for the 2021 regulations were materially the same as the reasons for the 2020 regulations, and were the reasons why, when the 2021 regulations were made, the legacy benefit personal allowances were treated differently. And that's absolutely right, they were materially the same. So, insofar as the case is material change in circumstances, we disagree.
What Mr. Brown, Mr. Burton says is that 37 should have gone a bit further and looked specifically at proportionality in the context of what was going on in the beginning of 2021.
Proportionality of what, though? Because we're not disagreeing with the evidence about there being an impact on the claimant's cohort. So all of that is known and understood. It was known and understood in March 2020 that the pandemic and lockdown was going to present grave challenges for everybody. And it was known and understood that that would include people in receipt of legacy benefits. That's why there was consideration given to that cohort as well. But the point is that there is nothing to justify a change in policy in March of 2021, because all the claimant can point to, I say all, I'm not in any way downplaying it, is that what was predicted to happen did happen, and that there were very serious impacts on that cohort in terms of their living arrangements and their ability to meet the increased costs of the pandemic. All of that was known. That just doesn't meet the question, though, as to, well, is the government actually obliged to do something? Is the government obliged to pay cash to meet those additional costs of the pandemic when that was not the objective?
For a different cohort.
Yeah, for a different cohort.
But wasn't Mr. Burton also saying that the evidence showed that the comparable levels of disruption were not, that the level of disruption predicted in March 2020 and indeed in March 2021, that could be seen looking back with hindsight, for this new cohort of people suddenly made unemployed as a result of the pandemic, were just simply not made out. In fact, they could cope very well. They had savings. They were less disrupted in reality. And the claimant cohort, the disabled people, were significantly more disrupted.
Yes, because the policy worked. That's the whole point. Because these three measures are introduced in order to mitigate what would happen if nothing was done, then the evidence suggests that it does what it's designed to do. So morale is not decimated in the way that it might have been. The labour market is damaged, but not damaged such that there can be no return. And the same applies to the economy. So the claimant's not measuring what government looked to do against what would have happened if it had just done nothing at all, where the predictions were extremely dire. Here, one has to consider that the policy did achieve all of those objectives. That's certainly the view of the government. And in those circumstances, it's inevitable that the cohort who benefited from it didn't actually then suffer all of the adverse impacts of the pandemic to the same degree as a cohort who did not receive assistance. So he's absolutely right, but that is the hard logic of the government's position in prioritising assistance to that cohort, is that they were always intended to benefit such that those adverse impacts were not felt in the same way, because that was to the overall benefit of the tax base and then to society as a whole. So we say then that the judge properly understood the way to approach this in terms of, first of all, deference. Secondly, understanding, of course, that the challenge was brought to the final 6 months, that was the correct focus, but he also correctly identified that could not be considered in a vacuum and failed to be considered by reference to what went before. So where is the error? It is suggested, and ground of appeal, is that Wilson requires the court to look at the position in November when it's hearing the case and to decide as of that date what the position is by reference to convention. It's not true, that is what Wilson says, but Wilson's dealing with a different situation. He's not dealing with a backwards looking audit of a measure which has now ceased. Wilson is considering the compatibility of legislation that's been on the statute book for some 20, 30 years, Consumer Credit Act,
Yeah.
at a time when the Human Rights Act has come into effect. And the logic of the House of Lords, their decision is that, well, obviously one has to consider the ongoing effect of legislation by reference to convention rights. Because Parliament has legislated to introduce the Human Rights Act, and of course that's the way then it falls to be considered. So it might well have been lawful when introduced, and cease to be lawful post-Human Rights Act. Nothing wrong with that. Here, though, that certainly requires the claimants to show that there has been that shift. So were the circumstances in relation to the legislation when it was introduced so different from the position at the time of challenge? So in Wilson, one looks at the position several decades after. So what might have been good in the 1970s is no longer fit for purpose in the 21st century. Here, we're talking about a measure which is being challenged some months after it's been introduced, when the government has actually decided to renew a few months before. So the government's considered the changing circumstances, and it's decided to introduce a different measure, i.e. 6-month extension. And at the actual time of the hearing, November, it's decided to let it expire as it originally intended to do so. So if one's taking the strict approach of Wilson, one would have to consider, well, November 2021 was position before the court, and position before the court in November 2021 is that there's no differential treatment at all because the measure's been withdrawn. So on that basis, there could be no discrimination. Even if the judge was, in fact, really just considering the legality of the decision in March 2021, which is certainly how it was argued below, we say, well, he did that then. So where's the error in the judge's approach? Because he directed himself to the March 2021 decision and said that it remained good for the original reasons and the new reasons, i.e. the circumstances before the government in January of that year. So there's nothing there that's legally erroneous. What Wilson does not say, and what the court plainly cannot do, is basically to conduct some retrospective audit and just decide today, well, did you actually achieve all of your objectives? You don't have the evidence for that at all. And you don't have the toolkit. It's not the court's function to decide whether the policy aims were good or bad, whether they should have been wider, whether it was appropriate to leave out certain cohorts, or to carry out the counterfactual and decide or seek to establish what might have happened if the government had done nothing, because that would also be non-discriminatory to simply do nothing, or if the government had decided to do something else. So we do respectfully disagree that there's any support in any of the case law for that sort of approach, where you decide after the event whether it was a good policy, whether it achieved the objectives. Even if you were to, we would say on the evidence that it was and it did achieve those objectives. So broadly speaking, those are my submissions. So unless I can assist the court, we invite you to...
Very clear. Thank you very much, Mr. Brown.
You've got a note before you sit down.
Oh, sorry.
Yes.
Thank you.
Forgotten something vital.
Yeah, it was actually answer to my lord's question. I think, no, it was my lady's. It was, what date was the public announcement of the decision to extend? So 3rd of March, 2021.
I only asked it in the context of you saying that these individuals could actually switch over onto universal credit in order to benefit.
Yes, and they could. Why does my lady say they couldn't? Because
of the
waiting period.
Yes,
Yes, I mean, we're
the
not getting
loss
into,
that they would have suffered.
there's advance payments that mitigate that. We were really going to end up going down a
Yes.
completely different
Yes.
case if we do all of
Yes,
that.
yes, it may not be legally relevant. I was just
Yes.
interested.
No,
Thank you.
absolutely. And so the answer
3rd of March.
Yes, the
Thank you.
White Witness Statement of paragraph 38, supplemental, page 88.
Thank you very much.
Yeah, thank you.
Thank you.
Thank you.
my ladies, my lord, I might not finish before lunchtime. Is that?
Or should we make a start?
Yes. Can I just then deal with that last question about Wilson,
Yeah.
the task of the court? There's no doubt at all that proportionality has to be assessed by the court.
Yep.
There's no doubt at all that that's a decision that's not delegated to any other body. Therefore, it would never make any sense to say we're constrained by the matters that were before the relevant body. The point about retrospective inquiry, as put by my learned friend, is, with respect, a red herring. If there's a policy decision to give a benefit to A and not B, and there may be a decision not to repeat that process, but benefit is given to one party and not the other, it is, of course, open to the person who didn't get the benefit to come to court and say that was an unfair decision or a disproportionate decision if it engages human rights. And then the court, obviously, in discharging its function and determining whether or not that was a proportionate or fair decision, has regard to all the evidence. It's as simple as that. Really is as simple as that. There's no basis for saying that somehow this court is prevented from doing it simply because the decision maker doesn't propose to repeat the exercise.
I think the point being made by Mr. Brown, and I may have misunderstood it, was the basis on which the court can assess that is on the basis of lawfulness. Was it lawful? Not, well, did she get the policy right? Would we have chosen a different policy? Were the objectives the appellants say, or were they the objectives the respondent relies on? I think that was more the point rather than...
Well, I've treated it in a very straightforward sense. I mean, obviously, if it's a disproportionate decision, it's unlawful.
Yes.
So in that sense, I was trying to address what I understood my learned friend to be saying about the scope of the court's inquiry in a situation such as this, where the difference in treatment is no longer persisting. But in the context of where a decision is made to give a benefit to A, not to B, as I say, that's fixed in time.
Yes.
I accept that.
Yes, we've got a fixed period of 6 months that we've got to look at.
So the broader question my learned friend was perhaps raising is, well, what kind of issues can the court look at?
Yeah.
And I fully accept that is constrained in the following way, that here we are looking at speculative decisions made by a decision or anticipated decisions, but this court's not so constrained in that way. It need not be. It does have the benefit, the added benefit perhaps, of being able to look at what in fact happened. The second point to make is that, yes, it's true that this court doesn't perform the function of, in this case, Secretary of State for Work and Pensions. It's not inviting the court to do that at all. It's inviting the court to assess the evidence by reference to the stated justification for the decision. Now, I'm going to develop this a bit more after lunch, if I may, but I just want to make the following point clear. I'm sure my lord and my ladies will have this, but the starting position for Ms. Parker is to say who's going to face the greatest disruption in order to justify the allocation of a scarce resource. And the conclusion reached is, well, we think it's going to be people who are going to suffer drops in income. We think they're going to suffer the greatest disruption during the pandemic. Therefore, we'll prioritise them. It's not the other way round. It's not who's going to suffer the greatest disruption as a consequence of drops in income. It's a very important difference. The first open question is, who gets the extra support? It's those who are going to face the greatest disruption. The analysis is, or the predictive assessment, that will be people who lose income. Therefore, we prioritise them. That's the structure of the evidence. That's why we get this analysis about comparisons between the greatest level of disruption. So insofar as the evidence addresses that question, it clearly goes directly to the question of justification. Now, there is a second issue, which I'm going to address if I can after lunch, about, well, is it so obvious that it's always going to be the right conclusion that it's people who are going to suffer drops in income who suffer the greatest disruption? I will address that. But more importantly, I want to focus the court's mind, if I may, in this way. We don't actually know what conclusion the Secretary of State would have reached, having regard to who ought to get the resource, based on who is going to experience the greatest disruption, having regard to what we know, i.e. what happened to the legacy benefit claimants in terms of disability and the impact on them, or indeed the demographics of the people who turned out to be moving on to universal credit for the first time. Not only is that because that couldn't have been known in March 2020, it's because you don't actually have any evidence from the Secretary of State analysing that material at all. You don't have a decision from the Secretary of State saying, okay, we've now looked at all of that evidence and we still maintain our position that the people who suffered the greatest level of disruption, such as to merit additional resources, are the people who are new to universal credit because of loss of employment, etc. That's not in Kirsten Parker's witness statement. And that's very important for the question of margin and deference from this court to the decision maker. You don't, the wide margin is predicated upon the decision maker themselves having formed their own view about proportionality, having regard to the same material. That's exactly what you don't have in this case.
Well, having regard to the relevant material, the Secretary of State doesn't regard that as the relevant question. The Secretary of State had the broader economy, social policy objectives. What can we do to make sure that the economy and the labour market bounce back very quickly in a situation of mass unemployment? And it's in that context that disruption was considered. It wasn't in the context of disruption at a micro level to people's household income and the poverty alleviation that you are talking about.
Well,
that's the point that's being made, which it feels like you're sort of walking in parallel lines that don't actually meet here.
Well, that's why I do think it's very important to understand that the first question that's being asked is, if the resource is scarce, who's going to get it? And you ask who's going to suffer the greatest disruption. So I know I'm repeating that, but
yeah, okay.
But if it's therefore implicit, if the answer always has to be people are going to lose income, that's a different way of tackling that question. I think what my lady is asking, well, the Secretary of State also took into account the additional benefits of prioritising this group. I understand that, but there are a number of points that could be made in response, and these are ones I was developing earlier. First of all, that doesn't necessarily explain why you don't also give the benefit to other people, first and foremost. But second, it's important to keep in mind this, that you then need to ask, what did this benefit actually do to achieve those objectives? What was it in kind? Now, the way it's explained is, well, the bounce back, it's the cushion. It's trying to ensure people who have gone out of work can come back into work. Well, we actually know this measure did very little to address that. They still lost their work, they still lost their income. So it was a cushion and only a cushion. And it's not a cushion that has been demonstrated to have any magic effect. There's no evidence from the Secretary of State about what the £20 actually did. None at all. But we do know statistically what it did, which is it did alleviate poverty for certain groups. There's no assessment or evaluation as to how that then led to people going back into work. Indeed, the patterns of work were the same. Now, my learned friend says, well, that's evidence of itself that it's working, and he speaks directly to the issue about evidence of comparable disruption. But there's an error in his assessment there. In fact, the evidence about comparable disruption was between existing UC claimants and new UC claimants, who all got the £20 uplift. And when that analysis was done, the existing UC claimants were much worse off than the new UC claimants. They all got the extra £20, but the new UC claimants came to the position in a much more advantageous position. The inference that the appellants invite the court to draw is, well, if it was comparatively worse for existing UC claimants compared to new UC claimants, it's going to be, by a different order again, comparatively worse for legacy benefit claimants who didn't even get the uplift. So that again goes directly to the balancing exercise about who suffered the greatest disruption. Then you ask, okay, what about the wider consequences? What about the additional benefit of getting people back into work? Just quickly on that, just in case this is overlooked, people on legacy benefits also work. They can work up to 16 hours. There's no analysis by the Secretary of State as to the impact of the disruption on their capacity to work, whether or not they lost that work. Similarly, the £20, if it really did have some magical ability to allow somebody to get back into work that they wouldn't otherwise have done, why isn't that equally available to everybody in the benefit system when Ms. Parker herself says the DWP takes the view that everybody on benefits should be helped into work, and indeed they are. It just doesn't justify the difference in treatment between the two classes, because it basically speaks to the same problem, which is the benefit's not enough to ensure good prospects of getting back into work. That's implicit in the rationale. But it doesn't work as a means of justifying the difference in treatment when looked at properly as to what it actually did, which is why I took you to that passage about these grander aspirations. There's no link between the £20 and those grander aspirations, save to the extent that people were prevented from moving into poverty. And that is deemed on the analysis to give them a better prospect of going into work. Well, that applies equally well to everybody on benefits. My ladies, my lord, might I ask to pause now, because I just want to collect my thoughts on some of the other points that my learned friend raised. I don't want to do it in a scattergun approach. I'm sure you won't appreciate that. It's only 5 minutes.
Very happy for you to do that, Mr. Burton. Thank you. We will we'll resume at 2.
Yeah.
We'll resume at 2 o'clock in any event. Thank you.